Morning.
Good morning. Broker associate because I'm teaching, so I have to be a broker. I've been in the business for over 30 years. And so I may not be similar to any of the other teachers. I'm here to help you out in whichever way. I believe in question and answers. I believe that is how it keeps it straight in your mind, because this way it forces you to look for the answers and to figure them out. And that's kind of how I teach in my regular classes. But for review, I find that doing question and answer is the best way to prepare yourselves, because basically that is what the test is all about. It's not reading a whole bunch of stuff from a book from Dearborn, but just a different kind of a version. Everything that we're going to go over, while we may not be going over in the same fashion as it is in the book, it is exactly everything that is in the book. Therefore, it's going to be jumbled in the sense that it's not going to be in a particular order, because again, the state exam is not in a particular order. I hope this helps you truly. Most important thing regarding the state exam is, as you all know, we how to read. Right now, we lost how to read because all we're doing is we're looking at initials: TXT, LOL, BRB. That's not reading. So the state exam is not going to be made up of those things. So therefore, you're not going to be able to be guessing that kind of stuff. It is a comprehension exam. And so when we're talking about comprehension, they want to know, are you understanding the question that they are asking? So in some instances, it may not be necessarily that they're targeting the actual category, but they're targeting, are you understanding what they're asking you? And then the second part is, do you know the information regarding that question? All right. That's basically how the state exam is made up. I will tell you, you need to read every single word individually. And I am not exaggerating, because the way they put the words in there, if you're not reading it exactly, then you're going to miss out on the correct question and the correct answer. If you're just going to skim, and I'm a skimmer, if you're going to skim, then you're going to miss that one or two words that will change the flavor of the question. It'll change the flavor of the question, and it'll have the answer to the improper answer, and it'll have the correct answer. So if you don't get anything from this review, just make sure that you read the questions. And the other aspect of it is that instances you might know the 100% answer. So my typical example is, at what point do you give the CIS? And so the correct 100% correct answer is at the first discussion, motivation and finances. That is the 100% correct answer. But that answer is not in the question. All right. So now you have a dilemma, because that 100% correct answer is not in the question. Now need to find an answer that is going to answer the question. Okay. And that applies quite often. So they'll ask you something, and then what we know as the 100% correct answer based on our textbooks and all is not there. And so we are going to have to find the next best answer to that question. And while it may not be 100% correct, it is correct in answering that question. Everybody good with that? Okay. That is the biggest thing that's the biggest thing that people have with the state exam, is that they don't read the question.
And also, process of elimination is a good thing to do in the state exam.
Absolutely.
And you know, an answer is not, it's not fitting there. You just eliminate.
That is absolutely correct. You will find two correct answers automatically, because there will be two answers that are absolute ridiculousness. All right. So then the choice is going to be which is the better answer to the question. And they will seem very similar and close in some instances, not all the time, but in some instances, the two good answers that we've determined, they will be very close. And that's why I'm telling you, read the question, because one of them is going to answer the question much better than the other. But I like the study book because it puts the math in the subject that it works at. Okay, so we'll just get going. All right, so we're going in a little bit out of order because, again, we're replicating how it will be in the state exam. Again, these questions are not as simplistic as the questions that you have in the book. And I chose it for a reason, because the state questions are not simple at all. We're going to start with this. We know that this is title records, so anything that has to do with title. Here we go. To protect the buyer, in some states, blank is conducted as soon as an offer to purchase has been accepted. What is that blank?
It said preliminary title search.
So yes, that is correct. Type of notice, that means the information is not only available, but that someone has been given the information and is aware of it, is called what?
Actual notice.
Ding, 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 ding. Good job. If a title has no serious defects, does not expose a purchaser to litigation, and does not cause the property to have a poor likelihood of resale, it is called
Marketable title.
ding, ding, ding. Good job. Woohoo. Rather than a certificate of title, in some parts of the country, an attorney's blank is used as evidence of title.
Taurus system.
No,
Even though we don't.
Action to quiet title.
nope. It's rather than a certificate of title.
Abstract of title?
No, that would be looking through the titles. So
Opinion of title. Oh,
ding,
no.
ding, 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 ding. Opinion
Oh,
of title is the correct answer. Okay. So it's usually the way it's worded in the book. It's worded abstract of title with attorney's opinion, but here they separated it. You can also have a certificate of title done by an attorney for rural areas. The premium for a title insurance policy is paid
Once at closing.
ding, 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 ding. Uninsurable losses, such as zoning ordinances named in a title insurance policy, are called
Constructive notice.
no. Good choice, but no. This is a title insurance. This is about title insurance.
Oh no, that one is H. Once at closing for 5.
Yeah, that was for 5, but for
Oh,
number
for
6,
six.
for number 6,
Rights of parties in possession?
no. All right, so the answer to that is exclusions. Just like any insurance policy, they always have exclusions. So uninsurable losses, such as zoning ordinances, would be called exclusions, items that are not insurable. A summary report of what a title search found in the public record is called
Constructive notice.
abstract of title. Ding, ding, ding. The standard coverage. Okay, hold on. The standard coverage title policy insures against hidden defects, such as what would be considered a defect?
Improperly delivered deeds.
Ding, 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 ding. Good job. All right. Number 9. Registration in the blank provides evidence of title without needing to make additional search of public records. Now, that does not pertain to New Jersey.
The Torrent system.
Ding, 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 ding. Okay. And the last one is the legal presumption that information about rights in a property may be obtained by a person through diligent questioning and research is called similar to actual notice.
Constructive notice.
Constructive.
Constructive notice. Ding, 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 ding. Good job. All right, let's go to fill in the blank. All right, what page am I on here? Page 5. Oh, yeah. So here it's about the real estate business, is what we're talking about. Whoops, sorry. All right, so we're talking about the real estate business. So, number 1, a person who conducts activities on behalf of a broker is called what?
Salesperson.
Salesperson. Okay. Let me just double check because I don't want to give you the wrong. So this is K is a salesperson, sales associate. Number 2, appraisers must have detailed knowledge of the methods of property. To do what?
Valuation.
Ding, 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 ding. Okay, hold on. I gotta admit people in. Admit all. Okay. Real estate professionals keep their skills and knowledge current by obtaining what? What's
Continuing
the-
education.
Good. Now, continuing education. How many hours is that?
12.
12. Good. And it's broken down how?
I know ethics is part of it.
Okay.
Ethics, the course, something like that. Fair housing, I believe. And
Okay.
ethics.
All right. So some of it is right, some of it is not 100%. So it's 1 hour fair housing, 2 hours ethics, 3 hours core. That's the first 6. And then the remainder 6 can be core topics or election topics that have been approved by the Real Estate Commission. All right. So
Okay.
that's our continuing education. Okay, number 4. A single family home is a type of what?
Residential.
Ding, 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 ding. If the supply of single family homes goes up and a major local employer lays off a large number of workers, the price of the real estate tends to do what?
Go down.
Go
up.
down, go
Go down.
down, ding, ding, ding. Okay, the splitting of a single piece of property into smaller parcels is called what?
Subdivision.
Ding,
Subdivision.
ding, good job. Niche marketing refers to the targeted marketing of specific blank populations.
Demographic.
Demographic, ding, ding, ding. Whoops, come back here. A community, a blank for mortgage interest payments is a benefit of home ownership.
Tax deduction.
Ding, ding, ding. A community implements land use restrictions so that less vacant land is available for residential development. At the same time, demand for housing increases due to higher population, so prices for real estate will tend to do what?
Go up.
Go up. Ding, ding, ding. And a blank is a person or company licensed to represent others in the purchase, sale, exchange, or lease of property.
Broker.
Broker. Ding, 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 ding. Good job. Okay, how do you guys like this so far?
Good.
It's
Good. Very good.
Okay, all right. All right, so here we are. Now we're talking about interests in real estate. All right, so again, we're going to be doing filling in the blank. So due to a court decision in 2005, many states are drafting legislation to establish a narrow meaning to the term blank in eminent domain proceedings to stop condemnations justified solely for economic reasons.
Public
Oh.
use.
Public use, ding, ding, ding. Okay. A type of life estate established by state law rather than voluntarily by an owner is considered what?
Legal life estate.
Ding, ding, ding. That would be dower and courtesy is what they're talking about.
What was
Okay.
the answer? Sorry.
It's a legal life estate. Okay, and that would be referring to dower and courtesy that ended May 28th, 1980. So prior to that, if a person got married to somebody and they owned property, they automatically owned it all together. So I guess in Gloria language, it would be community property. Whatever you have, I have. Whatever I have, you have. And that's the way it is. After 1980, that's not how it is. Okay, number 3. A fee determinable is qualified by a blank that ends the estate automatically on the current owner's failure to comply with this element.
The conventional?
No,
License?
no. Fee simple determinable. That's the word. That's the key word.
A freehold estate?
No. Determinable. Does it have a condition?
Yes.
Okay. Does it have a limitation?
Special limitation.
Yep, there's your answer, special limitation. Number 4, a life estate is a type of blank that is limited in the duration to the life of the owner or some other specified persons. Somebody already stated that.
Legal lifestyle?
Freehold?
We said that already.
Freehold estate?
No, a life estate. So if it's not a legal life estate, what kind of life estate is it?
Reversionary interest?
No,
No.
conventional.
Conventional.
Right? We stated that the life estate by state law, right? That's a legal life estate, and then a regular life estate is a conventional life estate. All right, it's a normal kind of a life estate. In a fee simple subject to a condition subsequent estate, the right of re-entry may never take effect. Therefore, this right is considered to be in a fee simple subject to a condition subsequent estate. The right of re-entry may never take effect. Therefore, this right is considered to be
Reversionary interest?
Yeah, but it is a version of that. But let's talk as to when it's taking place.
Future interest?
Future interest. Ding, 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 ding. Good job. It's taking place in the future. Okay. A railroad right of way is an example of what kind of an easement?
By necessity?
Nope.
Engross?
Engross, ding, ding, ding. Good job. It's a utility. Okay. Number 7. If the creator of a life estate does not name a remainder man, the original owner retains what upon the end of the life estate?
Reversionary interest?
Ding, 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 ding. Good job. A blank cannot violate any law, such as a fair housing law, by attempting to prohibit certain property transfers. Now that's kind of ownership. What kind of ownership cannot violate?
The deed restriction?
Freehold estate. Ding, ding, ding. Good job. Okay. When a claimant has used another person's land for a certain period of time in a manner defined by state law, the claimant can claim an easement.
By
By
necessity?
prescription?
Prescription, ding, ding,
Prescription.
ding. Prescription is the answer. Okay, because it's talking about for a certain period of time. How long is that time period?
20
30 years.
30 years
30
is the
years.
correct answer.
Mm.
Okay, in the book, I don't know I think in this book in edition 17, they corrected it. It is 30
Yes.
years.
Oh, because it says 20. Okay.
Yeah, the old one says 20.
Oh, okay. Well, it's the actuality is 30 years. And that's the answer you need for the state exam.
17 got 30. The old one got 20.
Okay, good. All right, there's okay. Thank you very much. Okay, so and what would be when you're thinking about easement by prescription? What would the words that come into mind? What words would you want to try to remember?
Neighborhood used to get to their property.
No, it's
What
open.
up?
It would be open, notorious, continuous, hostile.
Mhm.
Whenever you see those words, then you know they're
Mhm.
talking about easement by
And
prescription.
and also without the consent of the owner, I believe.
Right. But usually they're going to use in the state exam, they're going to put those words in. So you need to know
Yes.
that's easement by prescription. Okay, number 10. When two parties share a party wall that straddles the boundary line between the two lots, each lot owner owns the half of the wall on each lot, and they have what kind of an easement in the other half of the wall?
By necessity.
Necessity, yeah.
Nope.
Appurtenant.
Appurtenant. Ding, ding, ding. Good job on that one. An appurtenant because it's adjacent. Appurtenant means it's adjacent. They're right next door to each other. By necessity would be where the person has an easement and there's an easement to the property because they are landlocked. Okay. So as in order for me to access my house, I need to have an easement by necessity to let me in and out of my house. All right, because it's landlocked. All right, how are we all doing? I think we
Good.
did. All right, we did that one already. All right, so let's talk about state license requirements. All right, for a salesperson and a broker, what's the age limit?
18.
18 and above.
18 and 3 years.
18 minimum, right? Either or. Education. Is there special education?
School diploma
Just high school.
High
Yep.
school.
or
Yeah.
GED.
Good. All right. And experience for a salesperson.
None.
None.
Okay. And for a broker?
3 years.
At least.
Okay. 3 years.
As a
then-
salesperson, right?
As a full-time salesperson working with
Under
no
one-
other employment other than a
Good.
part-time job of 25 hours or less.
Ding, 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 Levada. You got that down pat. All right. Okay, bond. Do we need to have a bond? No.
No.
In New Jersey, we don't. Are they going to be doing a credit report for us on us in New
No.
Jersey? No. Okay. Do we need a recommendation for a salesperson?
No.
No.
Okay. Do we need a recommendation for a broker?
Yes.
Absolutely. Are they going to take photographs on either one of us?
Yes.
Yes.
Yeah.
Do we need to get fingerprints?
Yes.
Yes.
Do we have continuing education?
Yeah.
Good. How long is the license period for?
2 years.
2 years.
2 years. Okay. And when do the licenses expire?
July 1st, isn't it?
The odd.
Odd numbers.
June 30.
Odd years.
Okay. So there's a
July 1st, an odd year.
it's the odd year, but the license renews on June 30th of the odd year, and it becomes inactive or expires July 1st of the odd year. Okay, so we renew it on June 30th of the odd year, and then it becomes inactive July 1st. Yes, Vanessa?
No, I have no question.
Oh, okay, sorry. Okay. Continuing education. if we have to have continuing education, is there a date that we have to have it completed by?
So then, May 30th.
April 30th?
April
April.
30th of, and now they're going to, now April 30th is not a good answer.
Of the odd number year?
Yes, or they would also use the renewing year.
Okay.
Okay, so April 30th of the odd year or April 30th of the renewing year. That's how they would phrase it. But April 30th is not a good answer.
Okay.
Okay,
Or just a
Um,
question.
yes.
If you get a license on a even year after the 1st of June or July, isn't it valid for 3 years?
No,
Even if you pass the
the answer is no. If you got your license, let's see, what are we? Okay, here we are. So June 1st, let's just say July 15th, 2024, your license is good to June 30th, 2025.
So one of the answers, they're not gonna say July 1st, they're gonna say June 30th of the odd year. Because I get confused by those two.
I know.
Yeah.
So the renewal is June 30th.
That's what
Okay.
they're gonna test me on.
And the
I'm about to say June 30th.
expiration,
Okay.
the inactive or expiration, if you didn't renew June 30th, then your license expires July 1st of the odd year.
Same
Okay.
thing for continuing education. It's April 30, but expire May 1st. Right.
Yeah, exactly. Now,
All
are
right.
you going to have to pay a fee?
Yes.
Yeah.
Yes.
Mhm.
Okay. And if you don't get the continuing education by June 30th, is your license going to be renewed even though you paid that $200 fee?
Yes.
No.
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 Correct. No. All right. You have to, if you did not do your continuing education by April 30th and you paid that $200 fee and you still didn't complete it by June 30th, your license will not be renewed. Okay. And you'll have to complete the continuing education before you can renew your license. All right, so then July 1st, it will expire because you didn't renew it, and you'll have to do your continuing education. Once that's completed and it can be proven, then you can renew your license. All right. Do referral agents need to do continuing education?
No.
No. Okay. But if they decide to go from referral agent to a regular agent, do they have to take continuing education?
Yes.
Yes.
Okay. And just so you know, FYI, it's around 30 hours of core topics. So if you're a referral agent and and now you decided you want to become a regular agent, then you are going to have to take around 30 hours of core topics to get yourself set up as a regular agent, as a regular salesperson. All right, everybody good?
Yes.
Okay, thumbs up would be good. Whatever you want to do, that would be appreciated. But I do appreciate the conversation. All right, so now we're going to do a little bit of math. Oh boy. All right, so number one, a seller listed and sold an irregularly shaped parcel of land for $325,000. The seller agreed to pay the listing broker a 7% commission. The listing broker offered a listing 40-60 selling split. The way they worded that is weird. The listing broker offered a listing 40-60 selling split to any cooperating broker who sold the property. How much did the seller have to pay in commissions? Oh, we're in taxes. We're in real. Okay, got it. Brokerage. Okay.
seller. It should be
How
D.
much did the seller? How much did the seller have to pay?
Should be
All
D.
right. Okay, so we got two D's. All
D.
right, that is correct.
A. Oh,
No, it is D. Okay, so what did we do? We took the $325,000 times the 7%. Okay, and then we did the split.
So basically the 40/60, we don't really need to use
You don't
it.
need it in this example. No,
Oh,
they've
it's just
added.
to
giving us extra
confuse you.
info. Yeah, that's what
gave you-
confused me.
Yes, exactly.
Oh.
They gave you this information here. They gave you that it's an irregularly shaped parcel. They gave you a whole bunch of junk, right? I call them plants. They plant these things in there. So the answer is no matter what did the seller pay? The seller paid 325 times 7%. All right. And then that's the total commission. Now, if they went further and said how much did the selling agent get or whatever, then we would be using the 40/60, but they didn't go further than that. Okay. All right. Number 2, the sales associate agreement with the broker was a 40/60 split, with the broker keeping 40 of the commission. The seller was charged 5.5%. How much did the sales associate receive for obtaining the listing and selling a house for $279,500?
B? No.
Okay, what dollar amount?
C.
92.23. Oh, sorry.
Okay, the answer is C, $9,223.50. Okay, so what did we do here? All right, what we did was we took the sales price, right? We took $279,500 times 5.5%.
That's all over your face.
I'm sorry. Okay, so we took the selling price times 5.5. Okay, and then the broker is keeping 40%. So we are going to then multiply that number that we got, the commission number, times 60%, right? And therefore we got 9,223.
I did it like I multiplied the 60 first and then the 5.5. I still got the same. I don't know
Okay.
Okay.
All right.
Okay.
Again, everybody has their own way of doing math. Okay, so I'm not going to change you, but the proper way is to take the 279.5 times 5.5. You get the total commission, and then you're going to take the split from that. But again, do it whatever way works for you. Okay. The next one is a broker listed a seller's home for $425 with a 4% commission plus $3,000 for advertising costs. The buyer offered $380, and after several counter offers, they finally agreed to $400,000. What was the total brokerage cost to the seller?
C, 19.
Okay.
C, yeah.
Okay.
That's what I got.
19.
Also.
We got it. Ding, 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 ding. Good job. All right. So we took the price times the 4% plus the $3,000 for advertising. All right. Everybody good?
Yes.
All right. Good. All right. Number 4. Sales associate in a realty agency are compensated based on a formula. Okay. 35% of the commission earned on any sale, less a $200 per transaction desk rental. Sales associates are responsible for paying 75% of all marketing and sales expenses for any property they list, and a $75 per transaction fee to cover the monthly expenses of advertising and marketing agency services. If a sales associate sold a house for $500,000 with a 6% commission, how much would the sales associate be paid if the sale incurred $800 in marketing and advertising? No.
I got B2.
Okay, we are missing something. That's what I was just getting ready to do. Okay, so did you all do 500 times 6%?
Yeah.
Yes.
Yeah.
Okay. Did we all get 30,000?
Yes.
Good.
Yes.
And then did we all take 30,000 times 35%?
Yes.
Okay.
Yes.
And then did we minus the $200?
Yes.
Okay.
Minus 800.
Minus the 800.
Okay, but less a 200 per transaction desk rental.
Mm.
Okay. Then we also have a $75 transaction fee. Okay. And then we take the $800 times our 75% for marketing. All right.
And
So
that's what I did wrong.
okay. So so the correct answer is A.
9625.
Well, you don't subtract the 800 from the 10,000 something.
75% of 800.
It's the 800, but it's marketing. So what do we get charged for marketing? We only get charged 75%. Right? Are you still lost?
The planners.
The plans.
I got it. I think I got it.
We need a little more time in this. Yeah.
Okay,
This one is
so
pretty long.
To
That's
kind of,
okay.
to get all the inclusions and exclusions
okay.
in our heads.
All right. We'll slow it down. So that means anybody who gets an answer, we'll give it a couple
Little
more
time.
We'll
Yeah.
give more time. All right. All right. So here's another one. So we'll give time on this one. Okay. So a realty agency sales associates pay a monthly desk rent of 15% of their monthly income. By the way, this here is a perfect example of a business agency such as Remax. Okay. There are some other business agencies that charge these kind of fees. So this is not an unusual situation. All right. Not every agency does that, but if it's a business style agency, then they will charge you fees.
So is
Okay.
that like most franchises would charge those type of fees?
No. This
Okay.
is just a
Okay.
business style like Remax.
Okay.
Other businesses, other agency will charge a franchise fee, and the franchise fee could either be 5% or 6%. So if it's a franchise business, okay, then you will get franchise fees. But if it's a mom and pop business or it's not a franchise, you will not be charged those franchise fees.
Okay.
All right. Okay, so we're at number 5. A realty agency sales associates pay a monthly desk rent of 15% of their monthly income. In May, one sales associate receives 5% on a 560 sale, okay, and then 6% on a 348 sale, and 6.75% on 89,500. The only other sales associate at the agency who received a commission in May got 6% on 410. How much did the agency receive in May? All right, so I'm going to have to do this one. Actually, I think I will do it on the whiteboard if I can find it.
We've lost.
Yeah, I will. I'll bring it back. Just give me a second. Oh, where's blank? Why can't I just have a blank? Okay, there. I wonder if I could write on that. Okay.
I have B.
Okay.
No B.
Okay.
I need one more minute.
Okay. No worries.
I do have a question on the wording, if that's okay to ask while people are still
Sure.
going.
Okay.
Like I know how like the planners and all that good stuff, but I mean, it says in the beginning that 15% of the monthly income, and then at the end, it's like how much did the agency receive? Is that this what it's looking for? Is the desk fee that off of your income, I guess, for that month? Is that what that question's asking?
Mm-hmm.
Okay. Okay, good.
Yes.
Thank you.
Exactly. So Nancy, are you good?
Yes, thank you. I got the wrong
Okay.
answer, but I finished.
Okay. All right. So B is the correct answer. Okay. So basically what I was going to do is just so that you know what we're talking about, okay? And I'll just do it on here. All right. So what we did is we took 560, right, times 5%, okay? And we got 28,000. Okay, then we took the 348 times 6%, okay, and we got 2880. Then we took 89,500 times, what was it, 6.75, All right, and we got 60, 41, 50. All right, and then we took the 410 times 6%, and we got 24,600. Okay, so we added all of those up together, and we got 79,521.25. And based on what I think it was Sierra that asked the question, they want to know what did they get paid. So they get a 15% fee, right? The desk fee. So the answer is 11,928.19. Okay, so did that help you?
Yes, I see where I made my mistake.
Good. Okay, so that's what we're here to do, help you figure it out. All right, so that was that. Let's continue forward. Everybody feeling okay?
Yes, thank you.
All right.
Yes, ma'am.
Okay. All right. So now we are doing agency. All right. So we're going to do blanks on agency. So the basic framework that governs the legal responsibility of an agent to a principal is,
Fiduciary relationship.
okay. I would take that. I'll agree to that. Let me just double check to make sure I don't screw you up. And again, I'm in the wrong spot. So that's my answer. That would be my answer. Let me just get to the correct spot so we got it. Oh, I'm not in the fill in the blank. Ugh, I'm screwing myself. Okay, yes. No. The basic framework that governs the legal responsibilities. All right, the framework is what we're asking. All right, and the framework is the law of agency. Okay. So the law that governs us regarding agency is the law of agency. Okay. An agent who is authorized to represent the principal in one specific act or business transaction under detailed instruction is
Special agent.
ding, 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 ding. The individual who is authorized and consents to represent the interests of another is
General agent?
no.
Agent?
Agent, ding, ding, ding. Agent is the correct answer. The establishment of an agency relationship as a result of the actions of the parties that indicate mutual consent. Keyword, result of actions.
Implied agency?
Ding, 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 ding. An affiliation of trust and confidence as between a principal and an agent.
That's the fiduciary relation.
Yes. Ding, ding, ding. Good job. Non-fraudulent exaggeration of a property's benefits or features.
That's puffing.
Puffing. Ding, 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 ding. An agent authorized to represent the principal in a broad range of matters related to specific business or activity is
General.
good job. Ding, ding, ding. In a real estate agency relationship, the third party or non-represented consumer who receives some level of service and who is entitled to honesty and fair dealing is what?
Customer.
Customer. And the last one, an intermediary between a buyer and seller who assists both parties with the transaction but represents no one.
The non-agent.
A non-agent, and we in New Jersey would call them what?
The transaction broker.
Ding, 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 ding. Good job. All right. So now we're going into, what am I going into? Matching B. Okay. Agency relationship in which the agent represents two principals simultaneously without their knowledge or permission.
Undisclosed sole agency.
Undisclosed.
Ding. Good job. A contract in which the parties formally state their intention to establish an agency relationship.
Express agreement.
Express
Seems-
agreement, yes. And again, the key word, they state, so state is talking or expression. Created a registry of sex offenders that affects the real estate professional's duty of disclosure is what law?
Megan's
Megan.
Good job. Type of insurance that covers liabilities for mistakes and negligence in the usual activities of real estate.
errors
and
and
omissions.
omissions.
Good job. A property that has been branded as undesirable because of the events that occurred in or near it.
Stigmatized property.
Ding, ding, ding. Do you have to disclose it?
No,
No. If you're asked, do you have to disclose it?
you can
Yes.
send them.
Yes, if
Or-
you know it, yes.
You can
If you-
send them to proper people to find out what they have to say about it. Such as if they wanted to know Megan's Law, they'd have to go to the police and find out about sexual offenders in the neighborhood.
Right. But if we're talking about a stigmatized property, do we have to disclose that? The answer was
If-
no. But if we were asked, do we have to disclose it?
Yes.
Yes.
The
Yes.
book says yes.
Yes.
Wait,
Okay.
so is that specific to a stigmatized property that even
So
though we have
is-
knowledge of it, we're not supposed to disclose it until asked?
That's correct.
So it's
That's right.
similar to like a murder, I guess, or something like that. We don't have to disclose it unless asked.
That's correct.
But
Okay.
it's only, I heard about
Because-
it's only if you know the situation there. If you don't know, it's better not to disclose it, right? That's what I
If you know something, you still don't disclose it because it is not affecting the property. That's the key.
Mm-hmm.
As a stigmatized situation, does it affect the value of the property? And we're just going to keep it as general. The answer is no. In some instances, yes, but in general, it does not affect the property. It's not doing anything to the property. Okay, but if we're asked, then the answer is we have to answer, and you have to be very careful about that because you have to answer it only if you got it from the horse's mouth in Gloria language. All right, only from the horse's mouth. All right, if it's hearsay, it does not exist. Okay, and if they're concerned about it, then the answer is you send them it, like if they're concerned about murder or something like that, and you don't know, then the answer is you're going to send them to the police department, right? Because the police department will know if there was a murder in that house.
Yes.
All right. Because again, the key is if you heard about it, and let's say the murder occurred the house next door to the one that you're showing, and you tell them that yes, the murder occurred in this house, that's not the truth, right? And you could get into trouble for that.
And there's also a website that you can refer them to.
What
Yeah.
website?
It's NJP something. It's
That's
on the
that's
book.
for sex. That is for sex
Oh, sex
offenders.
offender. Oh,
I
That's-
bet you could Google the property and it would give you whatever you need also.
Sometimes yes, but again, if they want from the horse's mouth, then you send them to the police station. All right,
Okay.
because let me ask you this: does Google know everything?
No.
No.
Okay. So you don't want to you don't want to tell them to Google it. Let them do their own Googling. All right. If you don't know, you don't know. If they're concerned, go to the police station. All right. But all I'm showing you and talking to you about is the property. I understand you may have concerns about it, but I don't own the property. I don't live in the neighborhood. I don't know anything specific to that. So my suggestion is to speak to the police officers. And on the QT, you might say if you want to speak to the neighbors, which most of the times buyers will do anyway. I personally wouldn't push it that way, but if they, say something and I'll say, well, the neighbors live here, so I guess you could ask them that or drive around. Okay. But I don't want to say anything that could come back and haunt me. Okay. And like I said, I am full disclosure. I'm transparent and knock on wood, and I don't want to jinx myself, but for 30 years, I have not had an issue. All right. So if you're honest and upfront, you're never going to get into trouble. Well, never say never, but you, the
Generally
likelihood
speaking.
of getting into trouble is not there. All right. So we didn't finish this, did we? Okay. A contract in which the parties formally, oh, we did that already. All right. I guess we did. No, we didn't.
No, 6.
I think we're in 6. Yeah.
Okay. The principal in a real estate agency relationship is
The client.
the
No.
client. Okay. The agency relationship in which the agent represents two principals simultaneously with their knowledge and permission.
Disclose.
Disclosed dual agency. The responsibilities of care, obedience, accounting, loyalty, and disclosure.
B.
B, common law
Common
agent.
law.
Yep, duties. A person who is empowered to do anything the principal could do personally. This person has unlimited authority.
Universal agent.
Universal.
Universal agent, ding ding. A hidden structural problem that would not be discovered by ordinary inspection is known as what kind of a situation?
Latent.
Latent defect. Ding, 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 ding. Good job. All right, we're going to fill in the blanks. Okay. So the written employment contract that establishes the agency relationship between the seller and the broker is
Listing agreement.
ding, ding, ding. The requirement that brokers promptly
Wait,
deposit.
sorry, what was one again?
It was a listing agreement.
Oh, okay.
Okay. The requirement that brokers promptly deposit funds entrusted to the broker into an escrow account is an example of how brokers fulfill the fiduciary duty of
Accounting.
ding, 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 ding. Good job. Accounting is the correct answer. Within how many days must the broker deposit the funds?
5 business days.
Ding, 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 Giselle. Good job. Okay. Even when a property is sold as is or with a blank, the seller must still disclose known problems with the property if they will affect the health and well-being of the occupants. Now, they're not using the term that we would be using.
Confidentiality.
Seller disclaimer.
That's it.
Stigmatized
Ding, ding, ding.
property.
Seller disclaimer is the
What was it?
correct seller disclaimer. All right. And that would be the
Yeah.
same thing as seller disclosure, property disclosure, but they called it a disclaimer. Although not available in all states, when a person is authorized by the broker to act as the agent of a specific principal seller in an in-house sale by two agents, this agent is called
Designated agent.
ding, 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 ding. Good job. The intentional misrepresentation of a material fact in such a way as to harm or to take advantage of another person is called
Fraud.
fraud. Okay. Property discovery of a meth lab on a property can result in the property being regarded as
Stigmatized property.
stigmatized property.
Stigmatized.
Right? Stigmatized. A man tells a real estate broker that he has been thinking about selling his condo. The broker contacts several buyers that she knows are looking for a condo, and one makes an offer for the property. The broker presents the offer to the man who accepts it. Although no documents were signed by the man, an agency may have been created. How?
Implied.
Implied.
Good job. Implied agreement. Okay. If a buyer's agent reveals to the seller that the buyer must move within 1 month, this action would violate the agent's fiduciary duty of what to the buyer?
Confidentiality.
Ding, ding, ding. That is the correct answer. The source of blank does not determine agency.
Station.
No. Did you say compensation?
Yes.
Yep, that is the correct answer. Compensation does not determine agency. An agency is terminated by blank when a principal declares bankruptcy and the property title transfers to a court-appointed receiver. Termination by
Negligent misrepresentation?
no. We're talking about illegal here. Principal declares bankruptcy.
Operation of law.
Yes, that is the correct answer. Ding, ding, ding. Good
Which one?
job.
Which
Operation of law,
operation of
because it's a bankruptcy, right? And it transfers to a court appointed receiver. So that's legal. So that's law, operation of law. Okay. All right. So now we're going into client representation. All right. The agreements of client representation. So an employment contract for a broker's services for a property selling
Exclusive agency listing.
no. It's an employment contract.
Listing agreement.
Yes, that's it. Thank you very much. Ding, ding, ding. A listing agreement under which the seller must pay the broker a commission regardless of who sells the property.
Exclusive right to sell listing.
Ding, 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 ding. Good job. A listing agreement with a single broker under which the seller retains the right to sell the property independently without being obligated to pay a commission.
Exclusive agency listing.
Ding, ding, ding. Good job. A listing agreement in which the seller may employ multiple brokers and retains the right to market the property independently and is not obligated to pay except for the broker that produces a buyer.
Open listing.
Open.
Listing.
Listing. Good job. A marketing organization whose broker members make their own exclusive listings available to other brokers.
Multiple listing service.
Good job. Ding, ding. A meeting with the property owner at which a sales associate describes the marketing efforts that the brokerage, that the brokerage will make to bring about a sale of the property as quickly as possible.
Listing presentation.
Ding, 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 ding. An employment contract by which the broker is employed as a purchaser's agent to find suitable property.
A buyer representation agreement.
Good job. And language in a listing agreement that states the broker and the seller agree not to sue one another for any incorrect information supplied by one to the other.
Indemnification.
Good job. An optional item in the listing contract that protects the buyer against the expense of certain types of repairs after the sale is completed.
Home
Home
warranty.
Session clause.
Nope.
Home
Somebody-
warranty.
That is correct. Home warranty is the correct answer. And the last one, a part of the listing agreement that stipulates that the property owner will pay the listing broker a commission if the broker was the procuring cause of a sale that is completed after the listing expired.
B.
B, broker protection clause. All right. Okay. All right, let's do some math here. We're back to client representation. Okay, so we're representing sellers. Okay, so number one, a brokerage charged the seller $1,000 as an advertising fee and 4% of the selling price. The house was listed at $439,500 and sold for $429,350. What was the total amount the seller paid the brokerage?
C.
Did you say D is in dog?
No, sorry, C.
Okay. Anybody else?
It's D,
Same. B, none.
none of the above.
None of the above is the correct answer. All right. If you did the math, the correct answer is 18,174. Okay. So for anybody that did the math, that's the correct answer. But the correct answer here is none of the above. Okay. Number two, a seller agreed to a 5% commission on the sale of 175. The brokerage split with the sales associate involved 30/70. 30% remains with the company. So how much is the sales associate's share if the sales associate both lists and sells the property? And we're going to take time.
B.
Okay. Anybody else? Anybody else?
D.
Okay, I have two B's. Three B's. Okay. Is everybody good? Okay, so the correct answer is B.
Can you explain?
Okay, so let's go. So let me ask you this. What did you do 175 times 5%?
Yes.
Okay, good. And now we read that the person listed and sold the property. So does that mean that they get both sides of the commission?
Oh,
Was that a yes or a no?
no.
Yes, they do.
Yeah, they do.
Because if the sales associate both lists and sells the property, that means they get both sides of the commission. So basically, them and the office gets the full 5%. But then we know that there's always a split, right? So then we have to use the split, what number belongs to the sales associate, all right? And in this case, it's 70% of the 5% commission. All right, so 175 times 5% gave you the number, all right? And then you take that number and you multiply it by 70%, and you get the letter B, 6,125.
Oh, okay, I got it.
Okay, all right, good. Okay, number 3. It is the broker's office policy that salespeople keep 60% of the firm's share of any commission earned from any property they list. The salesperson listed a property that was later sold by a cooperating broker for $285. If the two brokers agree to the split of 6.5% commission equally, what will that salesperson receive? That's a weird one. Split it 50-50. All right, I'm not getting that one. That's not making sense to me. Oh, where's my pencil?
I got A.
Okay,
Still don't
Like-
get it.
you're very fast.
Only because I have a calculator. Yeah, I'm not a math person.
You're very fast. Let's see if I can get this to move over. There we go. Okay, Control All, Delete. All right, so now we're going to go with number 3. So we've got 285. Whoops, over here. So we've got 285, just so that we get it right. Okay, times 6.5%. Okay, and so therefore, I didn't get the number for that one. Oh, let's see here, grand. Okay,
Eight-
285, 1, 2, 3.
18,525.
18,525, right? And then they agreed to split that in 2, right? Which gives us 9262.5. Okay. And then we're going to have to take 60%. Actually, that's at times 60% times 60%. So that gives us 57.50.
Got it.
All right. So again, you have to read, you have to take note of what is stated in here. All right. Did that
So
help you?
basically, when they say share or split, not all the time it's divided by 2.
Not
Right.
always, no.
Not
because
always,
as
yeah.
you can see here, the salesperson got 60%, right? It says the policy is the salespeople get 60% of any commission, right? So the commission was 9262.5. Now we need to bring it down to the salesperson. So it's times 60%. And so that's the answer. Okay, better?
Shouldn't we be converting the 18,525 into 60%, which the agency takes, and then divide the answer by 2? I mean,
No,
like,
because that's not what it states here. If the two brokers agree to split the 6.5 commission equally, what will the salesperson receive?
no, that's okay. But the first line says the broker's office keeps 60% of the commission.
Of any okay, but read the whole thing. Again, it's back to words.
No, see,
right?
in this case, because they are splitting it 50-50, the answer would be the same. But in case it was a 60-40 split, then we would need to, give the agency 60% first, and then of the answer, divide it into 40 and 60. In this case, the answer would be the same.
Okay, I'm not quite understanding how you're coming up with that, because basically I'm just reading what's on here. Now you might, maybe mathematically
All
for
right,
you
okay.
it works, but I'm just not everybody's mathematical, and believe me, I'm one of those. So I can only go by what I'm
Okay.
reading.
Fair enough.
All right. So again, like I said, there's many ways to skin the to do the math, but I can only go by what it says on here, and that's how I follow it. And especially because I'm not a big math person, so I try to make it simple for people that are similar to me. Okay. All right. The commission on the sale of a house was 16,500, which was based on 7.5% commission. What was the final selling price of the house? Okay.
D.
Okay. D is in dog or B is in boy?
D as in dog.
Okay.
D. D.
D. Okay. All right, good. So that is the correct answer. Now I just want to go over something. Did you guys go through the part, base, and rate?
No, I basically just divided 16.
Okay,
by
right.
7.5.
But again, to make life easy, all right. Now it's PBR. Quick story. When I took my class, which was a long time ago, there was a beer can on top of the file cabinet because we did a physical class. And so we were always wondering why this stupid beer can was sitting on top of the file cabinet. And we figured that they didn't have a good cleaning crew, blah, blah, blah. So when it came to math, the instructor says, well, you see that can up there? It says Pabst Blue Ribbon. He says, so that's the formula that we're going to be using for math. So for me, that's what I always call it. And so this is Pabst Blue Ribbon. Okay. The reality, this is a partial number. Okay. This is the base. The base always equals 100%. Okay. And the R is the rate, is always a percentage. All right. So again, some of the math that you will get can be used with this formula. It's pretty simplistic. Okay. So in this, just to use it for this question, just as an FYI, what we're trying to find is this question here. So if we figured out that the commission here is partial number, so that goes up here. And then we were told that the commission percentage was 7.5. So that goes over here. All right. So then what is above and below is always a division. All right. And so in this case, we got the 100% number, which is 220. All right. Now, if you're using this formula, okay, so we got the partial number and we got the 220, and they want us to find out the rate. Again, what's above and below is a division. All right. So just so you know, again, this is keep it simple, stupid. This is Gloria's way of doing math. This number always goes first into the calculator. All right. So you're going to put 16,500 and then you're going to divide it by 220,000. And then we're going to get the commission, the percentage rate of 7.5. Now, let's just say we don't know what this is. All right. Now, mind you, we would do it normal, but let's just say for showing purposes, we have the 220, we have the 7.5. So when we have them both on the bottom, then this is a multiplication. All right. So hopefully that'll help somebody out there. Okay. All right. So we'll finish this and we'll take a break. So number 5, the broker listed a home for $360,000 under a 90-day exclusive right to sell listing agreement with a 6% commission. The next week, the broker began advertising the home in a local paper, showed the property to 2 prospective buyers. And later that week, the seller announced that he had decided to sell his house to a relative for $340,000. Okay, the seller is liable to the broker for how much?
B.
B.
Boy is correct. 20,400. That is correct. Okay. All right. So let's take a break. I'll see you back here at 10:45. Okay.
Okay, thank you.
You got it.
Thank you.
You're welcome. Okay. Hopefully everybody's refreshed a little bit.
Welcome back.
Welcome back, everybody. Thank you, Jamil. All right, so we're going to continue on. We've got about 10 more pages, so we should be done by lunchtime, and then we'll just do generic things. Well, some more stuff after that. Okay, so let's do contracts now. All right, we'll talk about contracts. We're going to do it as a true and false. So let's see what we know about that. An agreement to be bound by most of the terms proposed in an offer constitutes acceptance.
True.
True. Okay. All contracts must be in writing to be enforceable.
True.
False.
True.
Okay. It's false. Okay. So while
There's verbal. Yeah.
right, while contracts can be written or oral, only certain types of contracts must be in writing to be enforceable. But the reality is, for us as licensees, right, because that's really what we're talking about, our contracts have to be in writing. So we could start out verbally, and then with the parole evidence rule, which is the law that we have to have, if we started out verbally, then within 5 business days, it must be put in writing. Okay, otherwise it's not enforceable for us as licensees. Okay, a contract is only valid if it contains a binder.
No, false.
False. Good
False.
job. Okay, consideration is something of legal value offered by one party and accepted by the other as an inducement to act.
True.
True. An implied contract, the actual agreement between the parties is inferred from general or vague statements in the written agreement itself.
False.
False. The difference between bilateral and unilateral contract is the number of parties involved.
False.
No.
True.
False.
No. Okay, good. We all agree on that. Good job, everybody. A sales contract is executory contract from the time it is signed until closing. At closing, it becomes an executed contract.
True.
True.
True. Good job. All right. A contract that may be rescinded or disaffirmed by one or both parties based on some legal principle is void, even though it may appear to be valid.
True.
True.
Nope, that's false. All right. So the contract that may be rescinded or disaffirmed by one or both of the parties based on some legal principle is voidable, not void.
That's true.
Got
Voidable.
Got it.
Okay.
Voidable.
So just so you know, so it's
Gotcha.
voidable, even though it appears to be valid. So the trick word was void. It's actually voidable.
Got it.
The person who makes an offer is the offeree, and the person who accepts or rejects the offer is the offeror.
False.
False.
False. Ding, 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 ding. Good job. All right. The essential elements of a contract are offer, acceptance, consideration, legal purpose, consent, and performance.
False.
False. Good job. All right. Number 11, an oral agreement for
Could
the
you move that screen over? Just because I can't see the 10, 11. Unless that's me.
That must be you. It's not. I haven't touched
Oh.
anything.
Oh, I'm here. Sorry about that.
That's okay. No worries.
Thank you.
You're welcome. An oral agreement for the sale of real estate is unenforceable.
True.
True. True. Okay. Because the statute of fraud states that we have to have it in writing in order for it to be enforceable. Okay. The number 12, under a land contract, the buyer obtains both possession and legal title to the property by agreeing to make regular payments to the seller over a number of years.
True.
True.
Okay, false.
Mhm.
All right. Let's talk about it. Land contract, is that seller financing?
Yes.
Yes.
Okay. And in the land contract, does the seller retain ownership?
No.
Until it's fully paid up.
It's a quitable title that they retain, not full ownership, I believe.
No, that's incorrect.
Oh.
Land contract is seller financing, and the seller retains ownership, so they have legal title to the property, but the buyer has possession. So that is why it's false.
Got it.
Okay. So land contract is seller financing. A land contract is in this version is the seller retains the legal title to the property. Now there can be seller financing where it's like a regular deal where the seller is going to be the bank, but and the buyer is going to get legal title, meaning ownership and possession of the property. But in a land contract, that does not happen. All right, or it's also known as contract for deed. Okay, so in other words, we have a contract, we're making payments, we have possession, but we're waiting for the deed, which is going to transfer the ownership to us. All right, so that's another word for that. Assignment is a substitution of a new contract in place of the original one, while novation is a transfer of rights or duties under a contract.
False.
False. Good job. So novation, again, in keep it simple, stupid Gloria language, novation is new person, new contract, novation. For me, it was the 3 N's. New person, new contract, novation, but we still had the old person there. Assignment is you are still liable for that contract. All you did was you assigned over the possession of it, but you're still legally responsible. An offer or counteroffer may be revoked at any time prior to its acceptance.
True.
True. Ding, ding, ding. An option is a contract by which the optionee gives the optionor the right to buy or lease property at a fixed price within a specific period.
True.
False.
False.
Oops.
So, an option is a contract by which the optionor, okay, gives the right to the optionee.
Oh, they twisted.
They switched it.
Yeah.
Okay. So again, in Keep It Simple, Stupid Gloria language, OR is the owner. I own whatever it is, and EE is receiving it. So if I were to tell you that I am the mortgagee, who am I?
The lender.
Oh, good job. Ding, 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 ding. Okay. And the mortgagor, who am I?
Borrower.
Borrower. Okay, good job. Okay. All right. The Uniform Vendor and Purchaser Risk Act, which is a law, provides that the buyer bear any loss for damage to the property that occurs before title passes or the buyer takes possession.
True.
False. Before the buyer takes possession, who is responsible for the house?
Seller.
The
Seller.
Always the seller. The buyer only gets possession at the closing, so only then will they be responsible. All right. The number 17, the interest held by a buyer during the time between the signing of a sales contract and the transfer of title is called equitable title.
True.
True. Ding, 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 ding. All right. So now we're going into financing. Okay. So the borrower, I already did it. The borrower in a mortgage loan clause is
Mortgagor.
mortgagor. Okay. And the lender in a mortgage loan,
Mortgagee.
mortgagee. The act of signing a loan contract,
Dictionary note.
Executing. Executing.
Well, yeah, right. Number D. The borrower's personal pledge to repay a debt according to agreed upon terms.
Promissory note.
Good job. And the pledging, okay, I did that one. A financing instrument that conveys bare legal title on behalf of a beneficiary, but no right of possession.
Deed of trust.
Ding, ding, ding. Good job. The pledging of a property as security. I skipped one, I believe. The pledging of a property as security for payment of a loan without actually surrendering the property itself is
Hypothecation.
hypothecation. Good job. A charge for the use of money.
Interest.
Good job. The act of charging interest in excess of the maximum legal rate.
Usury.
Usury. A charge imposed by lenders to adjust for the difference between a loan's interest rate and the yield an investor demands.
Discounting points.
Acceleration.
Nope,
Oh.
discount points. You are correct, was discount points. The part of a financing agreement that gives the lender the right to declare the entire debt due and payable immediately upon default.
Acceleration clause.
That's the acceleration clause. All right, did I do the next one? Yes, I did. We're going to be talking about, all right. So percentage of loan amount charged to a borrower for the cost of generating a loan.
Loan origination fee.
A loan origination fee, correct. Ding, ding. The part of a financing agreement that requires the lender to execute a satisfaction or release when the note has been paid. The clause.
Efficiency clause.
Defeasance clause,
is-
ding, 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 good job. A provision in a financing agreement that permits the lender to declare the entire debt due immediately in the event the property is sold.
Alienation clause.
Alienation clause, good job. A device by one lender which agrees to change the priority of its loan relative to another lender. Keyword is priority.
Prepayment penalty?
No. One lender agrees to another lender regarding priority.
Subordination agreement.
That's it. Ding, ding, ding. A legal procedure in which property pledged as security is taken from the borrower to satisfy the debt. Oops.
A short sale.
No.
Deed in lieu of foreclosure.
No. Good guesses, but no. Legal procedure.
Illegal.
Foreclosure.
Closer.
Ding, 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 ding. Good job.
What was the answer? I'm sorry.
Foreclosure.
A foreclosure. Okay.
Okay. A document by which property is transferred to the lender by mutual agreement rather than by lawsuit.
That's the deed of, oh no.
Deed of lieu.
Deed in lieu. Yep,
Oh,
that's correct.
Deed in
A
lieu.
sale, a deed in lieu. All right. A sale in which the sales price is less than the remaining indebtedness.
Short sale.
Short sale, ding ding. A type of loan where each payment partially pays off the principal and interest.
Amortization loan.
Good job. A procedure for obtaining the unpaid balance of a debt where the foreclosure sale does not generate sufficient funds. Keyword sufficient funds, not generate sufficient funds.
Deficiency judgment.
Ding, 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 ding. Good job. Idea that a mortgage is purely a lien on real property.
Lien theory?
Yes. So a lien theory state is what we are. So what that means is that we own our property. Okay. And so the only way that legally, if we're going into foreclosure, the only way that the bank can get the property is they have to sue us. In a title theory state, that's other states that usually are west of us or a couple of south of us. It's basically like owning a car, where the bank and you own the property, and it's in a trust. Okay, so in this case, because the bank has ownership of the property as well as you, they can kick you out within 30 days, 60 days if you are not making your payments. So basically, they can repossess the property just like they would repossess the car if you didn't make payments. Make sense?
Yes.
Yes.
Okay. So a title theory, when the person pays off the loan, they would get what is known as a reconveyance deed. Okay. So they're reconveying it now completely to you in your name because you've paid off the loan. All right. The borrower's legal status on a deed of trust.
Trustee.
No, trust or.
Trust.
Trust or. You're still your ownership. A fee that a borrower pays on any payment made ahead of schedule, if allowed.
Repayment.
Good job. Okay. Now the
I
Okay.
thought I thought
That
there was no
doesn't-
prepayment penalty in New Jersey.
Yeah, we don't have prepayment. That's what I was just going to get into. That doesn't make sense to me because New Jersey does not have a prepayment penalty. Okay. So we do not have that. So in other words, if I were to purchase a property and today's my closing date and I got a loan and everything, and so we closed on it today, and tomorrow I won the lottery, I can pay off the loan and I'm not going to get a prepayment penalty. Whereas in some other states, you would have to pay a penalty because they didn't make any money on you, is really what it's about. All right. Number 15, on a deed of trust, a third party who holds the deed as security for the loan is known as
Trustor,
no trustee.
trustee.
Yeah, that's okay. That's okay. No big deal. You're getting it. All right. Okay, so that takes care of that. So now let's do mortgages. Okay, so we're going to use, this is our amortization schedule. So the amortization schedule will be available for you at the state exam, either on the table, okay, or it will be available on the display. You might have to click something for the display, okay? And so based on the questions, they'll tell you use the amortization schedule. And so that's where we're at. So here again, we've got the interest rates on the left-hand side, and on the right-hand side going across is the term of the loan. Just to go over quickly, that a loan payment, what does it include?
Interest,
And
Interest in time.
okay, principal and interest.
principal and interest.
Okay, so a mortgage payment, a loan payment includes principal and interest. So when we're calculating these numbers, we are calculating the principal and the interest. Okay. And so if we're talking about loans, we're going to be this is called a mortgage factor. Okay, so this is a mortgage factor. And so these are based per thousand. Okay, so if I have 100,000, then I'm going to have to divide it by 1,000. Okay, which means that I have 100 1,000s. All right, and if I were to say it's 5% at 5 years, I'm going to take that 100, multiply that by 18.87, and I will get the principal and interest. Okay, now as a reminder, interest. When we calculate interest, is it calculated on a monthly basis or is it calculated on a yearly basis?
Should be yearly.
Monthly.
No, it's a yearly interest. Okay, so if you need to find out what the monthly is, then if they're asking you what you're getting your interest is at 7% at 100,000, right? So that's $7,000 if I have that correct. And then they want it, bring it down to a monthly payment, then you're going to have to divide that by 12 to get the monthly payment. So in some instances, in the state question, they might give you the principal and interest, right? So they may have done that calculation for you, but now they want you to calculate the interest and bring it down to a monthly so that you can figure out what is the principal of that payment being applied to the loan amount. All right. So they won't give you that information. They'll just say the interest, the loan is 100,000. The percentage is 7%, right? And I'm just going to pick a number. It's not going to make sense, but the monthly payment is $665, right? So we took that 7,000, we divided that by 12, we got whatever that number is, right? And that number is the monthly number, which we will subtract from the 665. Everybody good in understanding that?
No.
No. Okay. All right, no big deal. Hold on. All right, so we're going to do it this way. Hold on. This is going to drive me insane. I don't understand why I can't get that arrow to move things. All right, so we'll go this way. Hopefully it's not going to open up. Yeah, it did. All right, so we'll do it from here. We'll start with this question here. Okay, a buyer wants to borrow $125,000 for 20 years. The buyer will pay 8.5% interest. What will be the monthly payments? So the first thing we're going to do is we're going to take the 125. If I turn on my calculator, it would help. So it's going to be 125, right, divided by 1,000. All right, so that's going to give us 125. And now they're telling us it's going to be 20 years. So there's 20 years. And now we have to go down to 8.5%. So 8.5%, there it is, 8.5%. All right, and now the mortgage factor for this number is 8.68. So now I'm going to take 125 times 8.68, and that's going to give me the principal and interest of $1,085. All right, so far so good?
Yep.
Okay, so now they're asking us in this question here, what will the cost of the interest over the life of the loan be? Okay, well, we have 20 years. Okay, so in 20 years, then we are going to have to take the 125. Well, actually, no, we're going to take the 1085, right, times 20. Well, actually, 20 times 12. Let's start backwards. 20 years, right, times 12 monthly payments, right? So that should be $240. I mean, 240 payments. All right. And now we're going to take the monthly principal and interest that we just calculated is 1085. All right. So that's what we paid off. We've paid off $260,400. All right. Now we're going to subtract the money that we borrowed. Okay. So minus 125,000. Add the zero. And we will get that the interest is 135,400. Are we good with that? Is that
Right.
helping you?
The second one I got lost.
You got lost. All right.
Yes.
So, all right, no worries. Hold on. That's what we're here for. All right. So Control A. Okay, Control A. Delete. Okay. So you were okay with where we got to the monthly payment, correct?
Correct.
All right. So we got the monthly payment to be 1085. I think I wrote it down. 1085, right? So the P&I equals 1085, right? Now the term, right, was 20 years. Okay? 20 years, right? So now they want to know what is the cost of the interest over the life of the loan. All right? So this is on a monthly basis. All right? So 20 years times 12 payments a year, right, equals 240 payments.
Got it.
Okay? So now we're going to take the 240 payments, right, times the actual dollar amount, which is 1085. So far, so good?
Yes, thank you.
Okay, so then we get, so when we do that, we get the total payment. What did we pay after 20 years to the bank? All right, so the total amount that we paid for borrowing $125,000, we ended up paying $260,400. That is principal and interest, okay? Because this here is principal and interest,
Got it.
correct? All right.
Yes.
So then we're going to take the 260,000. We borrowed only 125,000. So we're going to subtract that. Okay. And so then we are left with, what did I write down? 135, 400.
Excuse me, just one moment. Would it be the 260,400?
Oh, sorry, 400. Yes, sorry.
No, that's fine.
You are correct. You caught me. My first mistake ever. Ha ha.
Oh,
All right. So does that make sense now?
yes, I got it now. Thank you.
All right. You're welcome. Everybody good? Anybody else? All right. I know we got some math whizzes here, so, but don't worry about it. Okay. All right. So here we go. We're going to do this again, but this time you guys do it and you're going to tell me. So a buyer wants to borrow 200,000 to buy a house. If the buyer must pay 6.5% annual interest and can afford a monthly payment of $1,350, which is the principal and interest, what is the shortest loan term the buyer can afford? Oh, surely there's got to be an easier way to get it. Oh, there, finally. Okay. All right, how are we all doing with this one? That's what I know. All right. Anybody? Whoops. Gotta get a better way to do that thing.
$25 years.
That's correct. Do you want to tell us how you did
Yeah,
that?
that's
Do you want to tell us how you did that?
I could tell everyone if he doesn't want to.
Go ahead, tell me.
So the borrowing 200,000, so we have to do divided by 1,000 to be the stuff on the chart, so you get 200. I actually started with the highest loan amount. So
Okay.
I started at 30 at 6.5%
Right,
and did 200 times whatever I can't
Right.
see.
wait, well,
You
what
know, I
is
can't
it?
see what it was.
6.5, right? 6.5,
Yeah, I don't know.
which is right there, 6.32 at 30.
Yeah. And then saw that that was over the 1350 he could afford.
Right,
And then we did the 25 years, which is at 6.75 times that 200 that you originally got with the loan
Yep.
amount. And that gives you exactly 1350. So that's what you can afford.
Okay. So another way of doing that is also taking the 1350, that's a monthly payment, right? And then dividing that by the 200. And you'll get the same thing. You'll get the 6.75, and then you'll look up, because that's the mortgage factor. All right. And then you'll look up the 6.75, and there it is.
Yeah, so 200 divided by
Oh, that's
what you
cool.
can pay, that's 1350 gives you 6.75, and in the amortization chart,
Right.
it comes to 25 years. Yeah.
Yep. Exactly.
Yeah, that's less steps, actually.
So it just depends, whatever works for you. Again, the key is whatever works for you, because you are, as much as we don't want you to be under pressure, you really are going to be. So the key is whatever works for you. That's the bottom line. All right. All right, let's go to this last one. A couple plans to borrow $75,000 to buy a condo. If they obtain mortgage money at 6% instead of 7.5% on a 30-year loan, how much lower will their monthly principal and interest be? Okay, so we've got 6% versus 7.5 at 30 years, and the loan is 75,000. Oops, sorry. I did this again.
Can't see the question.
Yeah.
Okay, here it is.
Yeah.
But you still need the chart.
Yeah. Yeah.
So I'll get to the chart now so you can see it.
I can't do it this way.
Okay. So we have one answer. Is everybody okay? Do you need time? God, I hate this thing. Okay, so what did we do? We said 30 years. Right. 6% and 730. Is it 7 or 7.5? 7.5. Mm-hmm.
450.
Thank you.
It's 5 to 4.25.
Right. Should equal 74.25. Okay, is everybody good with that? Did you all see what I did? I'm sorry, what was that, Jamil?
No, I didn't say anything.
Oh, sorry. Okay, but somebody did, and I don't know who it was.
That would be me, Harjeet.
Okay. Mr. Colonel. All right, so everybody's okay with this?
No.
No. All right, so let's go over it again, right? The first thing, no matter how you look at it, when you're looking at for a mortgage, it's always going to be divided by $1,000, right? Because we're trying to get to the number so that we could use the mortgage factors, right? So $75,000, 75,000 divided by 1,000 gives us 75. That means there's 75 1,000s in there, and so they're comparing it at 6% versus 7.5% at 30 years. So that's consistent. Okay. So we go down 30 years, we go to 6%, going all the way across to 30 years. Our mortgage factor is $6. Okay. Then the next one we have to go down to is 7.5%. And we go across to 30 years, and our mortgage factor is 6.99. Okay. And so now we're just basically going to do the math. It's going to be 75 times the 6% mortgage factor, which is $6. So the principal and interest in this one is $450. And then we take again the 75 times the 7.5 factor, which is 6.99, which is $524.25. Again, that's the principal and interest, just so that we all know that. That's principal and interest. Principal and interest. Okay. So in this case, the answer, if we take the 525 minus the 450, there's a savings of $74.25.
Got it.
Okay, everybody good with that? Don't be afraid to ask, because that's what we're here for. Okay, and if I make a mistake, you tell me I make a mistake, and I'm fine with that also. All right, so everybody good with this?
I am.
All right. All right. Okay. So we won't, unless you want to go through some more math. Is everybody comfortable with math, or do we want to do another one? And I need a consensus here because I have 24 people.
I would like to do another one.
Okay. Anybody else?
Yeah, one more would be good.
Okay, good. So we're going to
I'm
go
okay with that.
All right, we're doing number 4. Okay, so number 4, they can afford $11.75 per month. Okay, that include now here's the trick. It includes principal, interest, taxes, and insurance. So this is a full nut. This is what they have to pay every month. All right, now they're telling us that the property taxes are $840, annual property taxes. The insurance will cost $480 per year. The current interest rate is 7%, and they want a 30-year loan. So how high can the loan amount be? And what must we do?
We have to divide 840 and 480 by 12 to
Good.
get the monthly.
All right. And then are we going to be subtracting it from our monthly payment?
Yes, as well as the insurance.
Right? We're taking away the taxes and we're taking away the insurance, right? That's where we divided these. So we got the monthly payment and we subtracted it from this total amount. We subtracted it from $11.75. Okay. So then in this case, we would have gotten $1,065. Are we all good on that number?
No, can you get me there again, please?
Okay. So the monthly payment is $11.75, correct?
Yes.
Okay. I think you told me, or somebody else told me, we take the 840 and divide it by 12, correct? Because it's
Yeah.
okay. So what is that monthly number?
70.
Okay, so we subtract that from 11.75.
Got it.
Okay, and then we did the 480 and we divided that by 12. What's that number?
3830.
Okay, so minus that from the number you just got. What did you get?
My calculator lost the other number, so I gotta do it again.
All right, so we'll do it again. So let's hold on. So we've got 11.75
Minus 70.
minus 70 mine's not on. 11.75 minus 70 equals 11.05, and then minus, what did you say, 40?
3830.
Okay, call it 40.
Okay.
1065. Did you get that?
Yes, I did.
Okay. Now, what else do we have here? Okay, so then we have a 30-year loan at 7%. So now we have to go back up here, right? I know everybody, I'm sorry about that. So we have a 30-year loan at What did I say it was? Ugh,
7%.
That's seven.
7%. So we've got the mortgage factor in this case is 6.65. Do we all agree on that?
Yes.
All right. So we are going to be, remember how we did it last time when we had the mortgage factor and we had a monthly payment? What did we do with that?
Divided by 12.
No, we had a mortgage factor and we had our monthly payment. That's what we got to. 1065 is our new monthly payment. That would equal our principal and interest. So what did we do with the mortgage factor? When we did the answer number 2. What did we do there?
Did we multiply by
You're
20?
we divided it. Okay. So in this case, the number that we just got, which is 1065, we are dividing that by 665. Okay. And then we're adding the 1,000 times 1,000. So I'll do it on the whiteboard. I'll move this over. All right, so we'll do it again. All right, so we got to our principal and interest. We all agree on that. So we got the principal and interest at 1065 after we subtracted everything. Okay, we all agree on that. So
Yes.
now we said that it was we said 7% interest and we said 30 years. Okay. So that equals our mortgage factor equals, I think it was 665, right?
Yes.
665.
Yeah, 665. Yeah.
So that gave us 665. So what we're going to do is we're going to take this number, right? 1065. We're going to divide it by 6.65. And we are going to get, what are we going to get? I didn't write that down.
160.15.
160.15, right?
Yeah.
So, but this mortgage factor, is it based on per thousand?
Yes.
Okay.
Multiply that.
So,
by 1,000.
so that means then we have to multiply this by 1,000. And so now it's going to tell us that this person can purchase a house for 160,150. Okay, did that make sense? Are you okay with that now? Everybody else is okay?
Yes.
Okay. All right, so let's move forward. All right, let's talk about the real estate transaction. All right, so now we are going into fill in the blanks. Okay, so the real estate transaction, the property map that indicates any encroachments and easements is called what?
Survey?
Ding, ding, ding. The second title search called the blank is done after the closing and is usually paid by the purchaser of the property. For us, it's not after the closing, it's beforehand, but we'll leave it at that.
Affidavit of title.
What was that? And we actually don't call it that. We call it, so I'll give you the answer. It's called, they call it the bring down, but actually we call it the rundown search. All right. And this is usually done right before, a week before the closing. All right. So they do the rundown, which is the second title search. They do the rundown search a week before the closing. And they will also do a credit report on the buyer a week before the closing to make sure that there are no changes either on the deed or there's no credit changes on the buyer where they no longer qualify. All right. All right. Number 3, mortgage loans made by banks, savings associations, lenders whose deposits are insured by federal agency, plus FHA and VA loans are called what? And are subject to the requirements of RESPA.
Federally related loans?
Ding, ding, ding. Good job. The form that itemizes all charges to be paid by a borrower and seller in connection with settlement is called what?
Corporation? Corporation?
No. Oops, sorry. No.
Loan estimate.
Closing disclosure?
Ding, ding, ding. Good answer. Closing disclosure. Okay. So, and when must they give the closing disclosure?
Is it 3 days before?
Wrong answer.
At the closing.
Wrong answer.
5 days?
At the very beginning,
Wrong answer. When must the closing disclosure be given to the buyer and seller?
3 days before closing?
Wrong answer.
3 business days before.
Thank
closing.
you very much. Ding, ding, ding. Got to remember that 3 business days before the closing. When must the loan estimate be given?
And for the closing disclosure, Saturdays are included as business days.
Depending on the bank, but the answer is that would not be a part of your question in the state exam. All right, it would be just classified as 3 business days. Because not all banks are open on Saturday. So when is the loan estimate given? Anybody?
5 days.
Not
3
5.
days?
Okay, no, that's not the right answer again.
3 business days before the closing disclosure.
Well,
Says-
that's the closing disclosure. When
But
must the
that's
bank?
same. 3 business days before. I don't know. I know it's 3, but I just remember before what.
Okay, so
Settlement?
no, let's start from the beginning.
Okay.
You're the buyer. You fill out the application, the mortgage application. What do you fill out in the mortgage application? What is considered a complete mortgage application?
Your address?
Date of birth, social security.
The aliens thing.
Aliens, good job. Aliens. If you remember that, that'll help you. Most important, if the social security number is included. So that is considered a completed mortgage application. Once the bank receives that, they have 3 business days to send the loan estimate and the home loan toolkit. Okay, so 3 business days after a completed mortgage application. That only goes to the borrower because the borrower is getting the money and they need to know, based on RESPA, they need to know what their costs are to borrow money. So that's the loan estimate. All right. The charges that the buyer and the seller are going to pay is going to be in the closing disclosure, and that will be given to them 3 business days before the closing. You got to remember those words together because 3 days is incorrect and you're going to have a wrong answer. Okay. Now, how many days must you have if you're going to close quickly? The bank says, we can close very fast. So how many days between the loan estimate and the closing disclosure must there be in between?
5 days.
No. So the answer is 7 business days. 7 business days. So we have after a completed mortgage application, we get 3 business days after the mortgage application. We get the loan estimate and we get the home loan toolkit. Do not forget that. That's part and parcel to it. Then we have 7 business days that we wait. And then they give the 3 business days before closing is the closing disclosure that is given to the buyer and the seller. Okay. Now, if the mortgage loan, the mortgage program for the buyer changed, does that buyer get a new loan estimate?
Yes.
Okay, and do we have a waiting period as a result of that also? Do we have that
I don't believe so. No.
Yes, we have that 3 business days waiting period. So if something happens with the buyer, they change the payment, they change the down payment, okay? They change the loan program, they change the interest rate, whatever it is, if it's going to affect and change the loan product, then they are going to get a loan estimate, a brand new loan estimate, and we are going to have that 3 business days waiting period. Okay, that's the finance law. Okay. A sworn statement. We're going to go to number 8 here. A sworn statement or blank is completed by the seller and assures the title insurance company and the buyer that there are no new judgments, bankruptcies, or divorces involving the seller on the title.
Affidavit
So
of
that
title.
means-
Ding, 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 ding. Good job. All right. Usually the blank pays for the recording charges, such as recording the deed that are due to the actual transfer of the title.
The seller,
No,
Buyer.
the buyer, right? The buyer is recording the deed, all right, because they bought the house. So they want to make sure that everybody knows that they own the house. Okay. All right, what do we have here? Taxes and liens. Oh yes, somebody said that they needed help with taxes. So here we go. Taxes, 162. But I want to go back here for a second. Mortgage loans. Yeah, let's go back to that. Okay, so let me ask you this. Does FHA give you the money?
No.
No. Who gives you the money?
The
bank,
lender.
The lender. Okay. So what does FHA do with the loan?
They insure it.
Good job. Ding, ding, ding. Okay. And VA loans, they are what?
Fully insured.
it's veterans insurance.
Fully insured.
No, they're not insured.
Oh, fully.
It's directly from the
guaranteed.
government.
Okay. An FHA loan is insured and a VA loan is,
Guaranteed.
thank you. Ding, 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 ding. Got to remember those two together.
Yeah.
Okay. All right. VA loan do they have to have a down payment?
No.
No. Okay. VA loan, is there a funding fee?
No.
Yes.
Yes, but they don't have to pay the fee, I think, right?
Okay. Well, again,
Funding fee, they have to.
They waive it. No?
no, it's never waived. A funding fee is never waived. It is paid at the end end of the closing. It can be paid by the seller, it can be paid by the buyer, but it gets paid. The key here is it gets paid directly to the Department of Veteran Affairs. Right, so it does not get paid to the lender, it gets paid to the Department of Veteran Affairs, and it is 1.75% of the loan amount. Okay, so VA loans, are they assumable?
I think they are, but you can't get
Yes.
loan until that loan is satisfied.
Okay, well, VA loans are assumable, and it depends.
They are, but you can't get
Yes.
loan until that.
Okay, the VA loans are assumable. All right, it's going to depend on when they were done. Okay, so if the VA loan was done prior to 1989, then it doesn't have to get any credit checks, it can be assumed. Or after 1989, they have to have credit checks and based on the lender's approval. Okay. Doesn't have to get any credit checks, it can be assumed. Or after 1989. Okay. The key with the VA loans, however, for the veteran is now again, Gloria language, if a regular human being assumes that loan, then that veteran still has that loan outstanding. All
Yes.
right. And they are then, whatever their eligibility is minus that loan if they didn't use up all of their eligibility. But if a veteran assumes that loan, then that loan zeroes out as far as the eligibility for the veteran is concerned. Okay, those are the specialties about that. All right, why do people want an FHA loan?
It requires like very low down payment.
Good. What else?
Lower
Yes.
credit score.
Okay, all right, they're more easy on the ratios. Okay. What is it that sellers don't like about an FHA loan?
Higher down payment.
What was that, Margarita?
It has a
Repairs.
higher down payment and it's insured directly with the bank.
A higher down payment?
Yeah, 20%.
Not for an FHA loan.
No.
Oh, I thought you were asking for conventional.
No, I said FHA. I
First
asked,
time home buyer conventional can do as minimal as 3% down.
yes. So why? So again, my question, we're all running around the question here. Why would a seller not want a buyer with an FHA loan?
Repairs.
And
The interest rate is lower.
no. What else does the FHA loan require? And the VA loan requires also.
Inspection or
Well, you said the inspection already, so I'm on the and part. The VA and the FHA require it. So it's something that both require it.
appraisal.
Yeah, ding, 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 ding. Good
All right.
job. All right. Now, what about the appraisals? What does it say?
Needs to come in like sale price or more, right? To be
Okay.
insured.
All right.
Well,
so-
because the seller has to pay for the appraisal
No.
valuation.
No. So when you're writing up a contract for an FHA loan or a VA loan, all right, you have to add the amendatory clause. That is what it's called, the FHA VA amendatory clause. And that amendatory clause states that if the appraisal does not come in at the contract price and or comes in lower, the buyer has the right to walk away without any penalties. All right. So that's the one reason that FHA is not liked by the sellers. And the other reason was that there's a inspections. Now in Gloria language again, I call it a house commitment. Until there is a house commitment, you are not going to get a loan commitment. So the appraiser is, in some instances with FHA, is the inspector and the appraiser at the same time. So they'll have the inspection, all right, and if it goes through, that if everything is good, then you'll get a house commitment, which means then you'll get the loan commitment, but then we will have to wait to see what the appraisal states. All right. If there's issues with inspections on the property, then those issues with the inspections need to be clarified before you would get a house commitment, because you'll have to be re-inspected, and then you'll get a loan commitment. And again, it'll depend on what the appraisal comes in at. All right, everybody good with that? Or did I confuse you? Okay. All right, so let's move forward. We got 5 minutes. Okay, generally in a court-ordered sale, which of these is paid first?
Real estate taxes.
Ding, 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 ding. All right, which of these is an example of a specific voluntary deed?
Mortgage lien.
Mortgage lien. Ooh, look at you. Okay. The millage breakout. Well, we won't do that right now. Okay. All of these are liens against property.
Lease pendants.
Okay. Except.
Lease pendants.
Okay. Good job. Which of these characteristics apply to a real estate tax lien?
The general voluntary lien. I mean, involuntary, general involuntary lien.
It's not general involuntary lien.
And it's specific involuntary lien.
Yes, it's a real estate tax lien. So it's specific, but of course it's involuntary. We didn't have to pay that. Okay, which of these would permit a law enforcement officer to seize and sell a debtor's property? Which one?
The writ of execution.
Ding, 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 ding. Good job on that one. All right, good job. All right, number 7. Does everybody know what that means?
Yes.
Okay. Well, there's only one person answering it, but okay. All right. All right. Number 7. Which of these is a general, statutory, and involuntary lien on both real estate and personal property?
Federal tax lien.
Ding, 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 ding. Good job. All right. A town wants to construct new concrete curbs in a residential neighborhood. How will the town most likely raise the money necessary for the improvement?
Special.
Good job. Good job. A lien that does not have to be recorded to be effective is what?
Real estate tax lien.
Good job. 11B, the market. All right, well, this is math. We're getting tired of that right now. Okay. Well, it's the truth, right? We're almost there. We got 2 more minutes and we'll be done. And then get ready for lunch. Okay, so to reveal any recorded liens, a property buyer should require blank before closing the real estate transaction. before closing the real estate transaction.
Title search.
Good job. That's correct. All right, the next one. A county assessor usually bases a property's blank on the sale price of comparable properties.
Well,
County assessor.
Assessed value.
Assessed value.
Assessed value. Ding, ding, ding. Usually, a vote of the taxing district's governing body is needed to impose a blank.
Tax levy.
Good job. Ding, ding. In many states, when a purchaser at a tax sale receives the blank, the purchaser gains the right to take possession of the property.
Certification of good.
A what? No. This is based on a tax sale. Now, we don't do this in New Jersey, so it may not be 100% correct, but you still need the answer. A certificate of sale is the correct answer. Now, in New Jersey, when you get a certificate of sale, tax sale is really what it is called. How long does the owner have to pay back the private person?
Is it 30 days?
Nope.
2 years.
2
2
years.
years. Ding, ding, ding. Okay. How long, if the tax sale certificate is taken by the municipality, how long does the owner have to pay back?
6 months.
6 months. What is the word if the municipality starts foreclosure? All right, we'll finish it with this one. It's called in rem. So if the owner does not pay back the municipality and the municipality wants to start a tax sale auction, which means it's going to go into foreclosure, it's called in rem, I-N and then R-E-M. All right. Okay, so we'll take lunch. I'll see you back here at 1 o'clock. All
Thank
right.
you.
Have a good lunch.
thank you.
I have one
Got
quick
it.
question. It's not about this topic. It's about something I'm still confused of.
Okay.
So, my quick claim deed, I know that is to clear the clause on title, but there's another thing that confuses me when they say suit to quiet title, because it
Okay.
could
So
either be one.
suit to quiet title means that there's something wrong with the title. Okay. So what does that mean? That means we all know that lawyers, if there's any lawyers here, disregard it. But we know that most lawyers don't do any work and they have their paralegals do all the work. And the paralegals are the ones that are busy typing away all these documents and everything. And so let's just say this one paralegal was really overworked and she missed putting in a middle initial for this particular owner. Okay. And so when they did a title search, they saw that Mary blank, then all of a sudden, well, actually Mary A blank, and then the next thing that we see is Mary blank. So based on the title search, these two don't match. And so now the title is basically screaming at the top of its lungs saying there's something wrong here. We're not connected. We're separated. There's a gap. There's a break.
So that's suit to quiet title.
That is suit to quiet title means that we're going to shut it. We're going to stop it from screaming at the top of its lung. And we are going to be using a quit claim deed to do that.
So then quick claim deed could be either clear to cloud title then, not
It
suit to
clears a
quiet.
cloud title. Well,
Okay.
the suit to quiet the title means we are taking away the cloud on the title.
Yeah, because in the state exam, it might trick you, but the correct answer is clear
Yes.
to cloud title. Yeah.
Yes, it does.
'Cause,
Yes, it
yeah, it
does.
might trick you. Yeah, because you could think about the suit also, but
Right, right. But a
Mhm.
quit claim
Mm.
deed will clear a cloud on the title, or it will be a part of suits to quiet title.
Okay, I got it.
All
Thanks.
right. All right. So have a good lunch.
Thank you.
You're welcome. Okay. Hopefully everybody's had a good refreshment. And we're ready and kicking, raring to go. You don't sound too happy about that.
Oh, yeah.
Overwhelming, huh?
A lot to take in. Yes.
Yes, it is. There's no doubt about that. How's everybody else doing?
I'm
Anything
here.
to say? A lot of info, good stuff.
Okay. All right. So, some of the items that some of you mentioned that you wanted to go over was appraisals, cap rate, chapter 8, agency contract, rules and regs. We're going to go over anyway. Anything else you want to talk about? I guess that sums it up for everybody. Okay. All right. So I'm not going to say that. I don't need that. All right. So, all right. Again, if somebody could do me a favor, if you can copy the link that was in the chat earlier and just put it in the chat for me, I'd be grateful because we're going to be going through some stuff again. So one of the things, so the other key point that I like is this one here. All right. Oh, actually, I have it open already. No, that's not it. Is that it? No, that's the statutes. All right, that's not it. This must be it here. Nope, it's not it. That's not it. All right, so I guess I got to open it. All right, so again, you all have this in the file folder that I'm sharing with you. And this is pretty concise as well. All right, so it gives you the words, the meanings, and all of that. So where I want to go to now is going to be taxes. All right.
Yeah.
Okay, hold on. Thank you. Alrighty. So one of the minimums that you need to know about, all right, is going to be the mile, the square mile. So the square mile, that is part of what? What kind of description, property description is that?
Townships.
Townships, good job. Okay. Now, is that something that we would be doing, or is that the other states?
Other states.
Other states, good. So that would be the rectangular government survey system. All right. The other thing that you need to know, memorize for the rest of your life, which is pretty simple, is an acre. So I don't know how you guys were taught to remember it. I was taught 7, 11. So if you add 4 and 3, that equals 7. And then the numbers go up, 5, 6, 0. So 5 and 6 is 11. And then you add the 0 at the end. All right. So 7, 11, Some people just memorize the number. For me, it's just easier to remember 7-Eleven. Or it could be 4 ladies, 35 years old, driving 60 miles an hour. Whatever works for you, but you do need to know that. All right. All right, we talked about that a little bit. I just want to get to the taxes right now for a moment, if I could find it. Client real estate contracts. What number am I at here? 300. Okay, so I have to go down more. Okay, here. Taxes. Okay, here we are. Okay, so basically a lien, right? Because we are a lien theory state. That means if we didn't make any payments for whatever it is, good, bad, or indifferent, we would have a lien on our property. All right, and it would that be a specific lien or a general lien? Okay. Would a lien, because I didn't pay something, would that be a specific lien or a general lien?
Specific to what they didn't pay.
Specific, right? If I didn't pay something. So in this case, it could be what they call a mechanics lien or a construction lien. All right. So again, just note that there are a lot of words there's a lot of different words for the same meaning. Okay. So mechanics lien, construction lien is the same thing. It's because I didn't pay people who worked on my house, so they have the right to put a lien on my property. All right. Now, is a lien considered an encumbrance?
Yes.
Yes.
Okay.
it is.
Good job. An encumbrance, can it be physical and financial?
Financial and what else? I'm sorry.
And physical?
Yes.
It
Yes.
could be both.
Okay. So it could be both. All right. Taxes, are they always paid first?
Yes.
Yes.
Okay, good, good. Taxes are also, what is the Latin word for taxes?
Les Perdo.
Place pins.
No.
Taxes.
What is the Latin word for taxes?
Oh yeah, these are.
It means general value.
Oh yes. Yes.
Ad valorem.
Ding, ding,
Yes,
ding, ding,
ad valorem.
ding. Good
Ad
job.
valorem.
Ad valorem.
Good. Ad valorem. Good job. Okay. If we let me just think here for a second. All right. Assessments, are they based on the true value of the property, or is it based on a percentage that the tax assessor put?
Tax assessor.
Yep, good job. Now, mind you, New Jersey is trying to keep everything at 100% market value, which in the current status that we're in is about correct. Okay, but basically, every municipality has their own way of taxing, whether it's a percentage or at 100%. But it is based on what the tax assessor deems necessary. Can the municipality do a revaluation if they feel that there's not enough taxes?
Yes.
Yes, every 5 years. Every 5 to 10 years, the municipality is allowed to do a revaluation. Okay. Taxes, are they paid by 100s or can they be paid by mills?
Both.
Both. Okay. And a mill equals
1,000.
1,000. Okay, good. All right. And that's basically what we've gone through already. So I think it was, I don't know who it was. Who was it that wanted to know more about taxes? Okay, we're not here. All right. So Okay, when you're not making payments on the property and the bank now wants to start the foreclosure proceeding, what do they have to do?
Send a notice.
Okay, and what else?
Eviction notice?
Eviction note? No. We own the property, so what must the bank do?
They
Yes,
should change the
fine.
title. They seize the property.
No, they don't seize it immediately, so that's not my answer to my question.
Give
Go
some
to the
time.
courts?
Go to court. Okay, good. Go to court is a good answer. And what do they record or file in court?
Foreclosure?
Liz pendant.
Ding, 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 Levada. Thank you
Liz
very
pendant,
much.
yeah.
That's what I'm looking for, right? So they're going to go to court and then they're going to file a lis pendens, which is going to be in the tax records, and it's going to let everybody know that there is some sort of legal action going to start here. Okay. Now, in order for the court or sheriff to enforce this lawsuit, this judgment, and everything, what kind of a document are they going to get?
A writ of execution.
Ding, 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 ding. All right. So that's the actual document that's going to allow the sheriff to come and and take over the property. A writ is the document, and so that's the order. A writ is the order, and then a writ of execution is the actual order to get it done. Okay. If I own a condominium, okay, and I have maintenance fees, and I did not pay my maintenance fees, what can the homeowners association do?
Put a lien on your home?
Okay, good. So in this case, then they would put a lien. Now, if I owned a co-op and I did not make payments on my maintenance fees, what could happen to the co-op owners?
All of them will
Take
be.
over your share?
They will all be responsible for the shortage of my maintenance payments. It's going to go to them. All right. An IRS tax lien, is that a general lien or a specific lien?
Specific.
General.
General. An IRS tax lien is general. A judgment, okay, is that a general lien or is that a specific lien?
General.
General lien. Okay, it's going to include everything, inclusive of your personal property. All right, so that's pretty basic on taxes. The mills, you need to know that some municipalities charge by the thousand, and some municipalities charge by 100s. So you have to be very careful in reading if there is a question regarding taxes. All right. Assessed value is again based on what the tax assessor is assessing it at. It is not, assessed value is not the purchase price. All right. It is not the market value. It's what the assessor is putting to that property. All right. Now, the municipalities, they if one municipality is paying more than another municipality, then the assessor could add what they call an equalization factor. Okay, so the key to the equalization factor, what you need to remember is that you need to get the assessed value to the new equalized value. So you have to do that math first. All right, that's very important. So here we are. No, here we're not. Here we are. Okay, so the equalization is based on, we're trying to keep all of the taxes equal amongst all the counties and all the cities. And so if one is paying less than the others, and it's been deemed that we need to use an equalization factor, then the key to the math aspect of it, what you need to know about it, is that you need to do the math before you get to the point of figuring out what the new taxes are. Because in essence, that's usually what they'll ask you. What are the new taxes based on the new equalization factor of whatever number they gave you? In this case here, it's 1.25, 125%. And so you need to do the equalization factor first, get to that number, and then take that number and figure out what the taxes are going to be. So typically they will give you a rate, a tax rate, and you'll be using that to figure out what the new taxes are going to be. And again, be very careful in looking at the wording, because they might ask you what are the monthly taxes, yet everything else they've given you is in a yearly number. All right. So again, read the word, and then you know that whatever number you got to, you're going to have to change it to 12 months. All right. All right. What else? All right, so we talked about mill is 1,000, tax bills. Okay, so the taxes are paid in arrears. That's another question that comes up. So taxes are paid. You live there 3 months, you pay the taxes. You live there 3 months, you pay the taxes. So that is called in arrears. Okay, rent in New Jersey is paid in arrears as well. However, most of us write the leases that we start on the first of the month. All right. But if you have a private individual that is not specifying it, then you will be paying it after you've lived there a month, and then you'll pay them rent. So again, you need to be very careful about the leases as well. We talked about the right of redemption for a tax sale certificate. So it's 2 years. So that is called the right of redemption. Well, actually, let me rephrase that. The correct terminology is, before the tax sale auction, you have the right of redemption to pay everything off before the tax sale auction. But after the tax sale auction, you then have the statutory right of redemption. So statutory means you have the lawful right of redemption up to 2 years. All right. And if you don't pay, now mind you, the tax certificate holder cannot take possession of the property. All right. All they did was pay the taxes on your behalf, and now the owner has to pay them back. If they don't pay them back within the 2-year mark, then the tax certificate holder can then start the foreclosure proceedings. All right. And they have up to 20 years to do the tax sale proceedings. All right. Here's the in rem that I told you about. So again, the statutory right of redemption for the owner for the municipality is 6 months. And if it's not paid then within 6 months, then they could start the in rem proceedings, which is the foreclosure proceedings. All right, everybody good with that?
Yes.
Okay, thank you. All right, capital gains. So you have to live in your property as a primary property, very important, primary property, 2 out of 5 years. All right. And so if you're married, you have $500 capital gains exemption. If you're single, it's $250. All right. But you have to have occupied it officially as a primary residence for 2 out of 5 years. Most important part. All right. So that's taxes. Okay. So the next one, we had appraisals and cap rate. All right. So appraisals, okay. Capitalization rate is something that they are going to be asking you on the state exam. A lot of students came back to me and told me they had a lot of that. Okay. The other thing that people came back, which I want to go over before I do cap rates, is the mortgages. So the one that most people tell me that they get is the adjustable rate mortgage. But what I do want to go over, this is very important. All right. We state that we give a mortgage to the bank. Now, again, in Gloria speak, in Gloria in Gloria language, okay, the legal bundle of rights in Gloria language are balloons. All right, so I'm holding on to all of my balloons, and these are my legal bundle of rights. So if I want to lease my property, I'm going to give my balloon to the tenant, and so they are now able to lease my property. Obviously, I have a lease as well. Now I'm going to give the bank a balloon because I need to get a mortgage to buy this house. So I'm giving them my balloon. I'm giving them the right to lend me money to buy a house. So visually, that should help you. It helps a lot of people. So visually, I am giving them the balloon to give them the right to give me a mortgage. All right. So when we say a mortgage actually has two documents, and so you can't just say mortgage. All right. So there's two documents. We have what we call a promissory note. It's a note, or it's also known as a bond in other states. Understand that certain questions in the state exam are national state questions and national questions, and then you have state specific questions. So a note or a bond is a financing instrument. So what it's basically saying is I promise to pay you on the loan that I am borrowing, which is $100,000 at 30 years at 5%. The mortgage payment is whatever the case may be, and that's that. And then the second document that we're signing off on is called the security instrument. And here it's basically saying, okay, if I don't pay you, then you have the right to foreclose on my property. Now, in New Jersey, you're going to have to sue me for my property. In any other state, if it's a title state, they can just repossess it. All right, because it's a title state. So in this case, so a mortgage consists of two documents, a note or bond and a mortgage, all right, or a financing instrument and a security instrument. Now, the financing instrument can be sold on the secondary market by the banks. So again, in Gloria language, banks have to have a certain amount of money at the end of the day. So if they are short at the end of the day and they don't have all that money, then they'll go to the secondary market. They'll sell a note so that they can replenish their till, their vaults. All right. So the bank sells the note on the secondary market. Now we talked about, so those are the basics regarding that. Okay. Then the next basics, again, because they asked these questions, is regarding well, we know amortized loan is a loan that has been calculated for the set amount of years, and you are paying the same amount every year. And basically it zeroes down, gets down to zero. So it's a dying loan, or you're killing off the loan. On the other hand, you can have a loan that's increasing because you're not making enough payments to pay the interest rate. That is called negative amortization. And so that's a breathing, living loan because it's getting bigger and bigger and bigger. A good example of that would be a reverse mortgage. All right. A straight loan is also known as a term loan, is basically interest only. That's all you are paying. So if you borrowed $1 million 5 years from now, and you've been paying interest only for 5 years, you still owe $1 million. All right, that's what a straight term or straight term or term loan is considered. Partially amortized loan is, yes, it is a loan that is fixed, that the payments are the same for every month, but at the end of the term, whatever that term may be, it didn't zero out. You have what is called a balloon payment. All right, so that's a partially amortized loan. Adjustable rate mortgages, and this is where we need to go over a little bit. So adjustable rate mortgages can be adjusted at 3, 5, or 10 years, or they can be adjusted yearly. All right, this is something that it's a risk or reward for the buyer, depending on what they need it for. Typically, someone getting an adjustable rate mortgage is because they're going to be living there not a very long time, or they can't qualify for any other loan, but they can qualify at a lower rate, and so they'll take the risk to get a mortgage at a lower rate. And it might adjust every year, and they'll take that chance, hoping that the interest isn't going to go too crazy, but they are still protected because we have several things that happen with the adjustable rate mortgage. So the first thing is that we have the adjustment period, right? So it could be a year, 3, 5, 10, whatever it is. We have an index. So the index, the interest rate is based on the index, and depending which one it is, it could be Treasury or it could be London. All right, that's what the bank is borrowing the money. So in this case, in my example, the bank is going to borrow the monies at 2%. All right, and then they want to make a profit. So their profit is called a margin. So they're going to add on 2% on top of their 2%. So basically, we now have a loan with an interest rate of 4%. All right, that's a pretty basic one. Okay, now, again, to protect the consumer, they're saying that we are then going to have an annual, because we're going to talk about an annual. All right, so we're going to have an annual cap adjustment, meaning that at the next time that there's an adjustment, the interest rate cannot go more than 2%. All right, so we started out at 4%. Now at the end of our anniversary of our loan, the interest rates went up 3%, but our cap rate is 2%. So we can only add to our payment is 2%. So now we're going to be charged our payments at 6%. 4 plus 2 is 6%. The bank then has a choice that they can either forgive that extra 1% because the interest rate went up 3, so they could forgive the 1, or they could put the 1 and save it till next year, or they could put that 1% and put it at the back on the principal, and it'll start collecting interest. All right. Until next year, and then we'll see what happens. So that's the cap rate, okay? Then the next one is, okay, so now we have a cap rate, but I want to know, what is my worst case scenario? I mean, if it goes up to 20%, I definitely can't afford that. So they have also what they call a lifetime cap or a ceiling. So here we started out at 4%. We added on 2%. I don't know what the hell is going on. We added on 2%. So we're now at 6. And so now we're saying that we have a lifetime cap. In this example, we're going to say we have 5 points. So we started our loan at 4. So our ceiling is going to be 4 plus 5. So that equals 9%. So our ceiling or our lifetime cap is 9%. So that means my percentage can never exceed 9%. Okay. So here we're at 6%. And as we continue on, it stays at that, or it goes down, goes up, or it goes down. But bottom line, the ceiling is the worst case scenario. So if somebody's worried about what is the worst case scenario, if it's a really bad time for mortgages and they keep on going up, what is my worst case scenario? I'll know that this is the amount and I can never go beyond that. All right, everybody good with that? Okay. Any questions?
No, that's clear.
Okay. Okay. The other thing that you need to know, they may ask you this question again with the amortization schedule. So again, in this case here, what the heck, let's move this out of the way. All right. So here they're telling you that the loan is 100,000, 30 years, 7% interest. They have given you the monthly payment. So what does this include? The 665.31. What does it include?
Principal,
And
interest,
Good.
taxes, and insurance.
no. No. This is the mortgage payment. Mortgage payment is only principal and interest.
Oh, right. Okay.
Okay.
I thought you said something else. I'm sorry.
That's okay. So this is the mortgage payment that they're giving us, right? Now
Yes.
their next question is going to be, it's further down here, but we might as well do it here. The next question is, what is the principal after I made my first payment? Okay. So what we have to figure out then is we know what the principal and interest payment is. We need to figure out what is the interest. Would that be a fair statement?
Yes.
Okay. So in this case, then, hold on, Control Delete. Okay. So then in this case, we know that it's $100,000. Okay. And it's 7%. So interest is calculated, is that on a yearly basis or is that on a monthly basis?
Should be monthly.
No, it's calculated on a yearly basis. So I'm borrowing 100,000. My interest is 7%. So 100,000 times 7% equals 7,000, and that's 7,000 for the year. All right. Now I'm going to have to take that 7,000, divide that by 12, which is going to give me the interest rate of 583.33. That's the interest monthly. Okay. So far, so good?
Yes.
Okay.
Yes.
All right. So now the question was, what is my principal after I make my first payment? Well, we now have the interest, right? We've been given we've been given our mortgage payment, which in this case was 665.31. That's P and I. All right. So I just finished calculating the interest. So now if I take 665.31 minus 583.33, all right, I'm going to get, based on the book here, is $81.97. So my loan was 100,000. Now I'm going to minus 81.97. And my principal after the first month's payment is going to be 99,918.03. Everybody good with that? Makes sense?
Yes.
Yes.
All right. So just to go over that, just so that you all understand that. Now, they might make you do it twice. They might say, well, what is the principal after 2 months payment? So then what you're going to do is you're going to now take this new number and multiply it by 7% and get the new number, and then go through the same thing that we just did here. All right. Everybody good with that?
But
Yes.
why would we do it monthly if the interest is for the year?
Because my mortgage payment was given to me on a monthly basis. See, monthly payments of $665.
Yes.
So after the first month's payment, what is the principal? Right?
Mhm.
That's the question. So what did I do? I calculated what is the monthly interest because I'm only given the principal and interest. I have to figure out what is the interest so that I could figure out what the principal is. This is the principal that was paid towards this number here.
Okay. Yeah, that's okay.
All right. And so that's what I did.
Mhm.
So my new principal after 1 month payment, my principal is 99,918.
Okay.
That's after 1 month's payment. Now they might say 2 months payment, they might say 3 months payment. The bottom line is you're going to have to take your new numbers and then just do everything that we just did initially, do everything again the same way. This is a constant. This is a constant. This will not be a constant. Okay? Make sense now?
Yes.
Okay, thank you. All right, and as you can see, just to show you that these are the numbers here. If they did 3 months payments, as you can see, the principal is different. Okay, and the interest obviously is a little bit different, but you will need to do that if you're going to be, if they ask you that question. Okay, points. Okay, this is where everybody also gets lost on. Points are calculated on what? Whoops. What are points calculated on?
Loan amount?
Loan amount. Thank you very much, Sierra. Appreciate that. Okay. So remember, it is always on the loan amount, never, ever, ever on the purchase price. All right. And a lot of people forget that. So the answer is it's always on the loan amount. Again, in the state exam, they might ask you, they might give you questions in all sorts of various forms. So they might give you a question that gives you the full purchase price, and then they tell you that they put down 20%, and then they have to pay 3 points. So you're going to have to figure out what the down payment is to get to the loan amount so that you could figure out the points. All right, they don't make it easy. Okay, we talked about so we talked about the 3 business days and the 7 business days. All right. The next thing that you need to know about is when we have a conventional loan and it's under 20%, what do we have? What extra payment do we have to pay because we put down less than 20%?
PMI.
PMI, okay? And with a conventional loan is once that property gets 22% equity, does the bank automatically take it away?
Yes.
Yes.
Yeah.
With FHA, if we put down less than 20%, what's that extra payment that we're making?
Mortgage insurance?
Mortgage insurance? Well, that's not a good answer. It would be MIP, mortgage insurance premium. Okay. And does if the property reaches 22% equity, will FHA automatically take away the MIP?
No.
No. Good job.
No.
Ding, 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 ding. Okay, good. All right. All right. Again, here, very important. We're talking about the FHA VA addendum. All right. So if the purchase price is higher than the FHA appraisal, the buyer must pay the difference in a cash down payment or decide not to purchase. Basically, they can walk away without any penalties. Okay. Also, with FHA, you have repair requirements. Okay. Now, as far as laws are concerned, if you, actually, let me back up. On FHA and VA, can it be an investment?
No.
No.
No, absolutely not. It has to be owner occupied. Do not get involved if someone tells you that they're going to be renting it out. All right, that's mortgage fraud, and you will be a part of that mortgage fraud if you help them to go forward in purchasing that property. All right, experience talking. I walked away.
I have a question though. If it's a duplex that they can live in, and they can have it as investment property, that's okay, right?
Yeah, 1 to 4 units, but they have to live in one. They can't rent out all 4 units or all 3 units or all 2 units. They have
They
to
have to do this.
they have to physically live in one unit. All right, very, very important.
I
Okay.
got a question.
Sure.
Is it true that with VA loans that after like a certain time frame, like say 2 years, that then they can then rent it out? Or
I think there is a time limit, but I don't know that, and we don't need to know that for the state exam.
okay.
All right. So my answer to you is you are going to develop relationships with mortgage bankers, mortgage lenders, whatever you want to call them. All right. Loan officers. And you do want to get several. Okay. You want to get friendly with several. One for a VA, not all lenders do VA, and you want somebody that is I have a guy that I can lend you, that I can give you, but you want somebody that is very well versed with VA. You don't want somebody that just does a VA loan every now and then. You want somebody that does VA all the time, because it's different than all the other loans. All right. And then you want another lender that does FHA loans, that does NJIMFA loans, and then just a standard conventional. Now, those two can be one person or several people. Just know that when you are recommending people, how many people must you recommend?
3.
3. Okay. Of the 3, depending, not just mortgages, any kind of recommendation, of the 3, can it be a family member?
I say no.
Okay, the answer is yes, as long as they are certified for the job, right? If there's a license required and they have a license and they're a family member, absolutely you can recommend them, but you have to recommend 2 other people. All right. And then my next question that does come up on the state exam, are you recommending these people because you're getting money from them, or you're recommending them because they did a good job?
Did a good job.
Good job. All right. Kickbacks are illegal, and that's under RESPA. The RESPA law says we cannot get any kind of kickbacks. All right. We talked about the repair requirement. We talked about must occupy the property. We said that they are assumable. Again, depending on when it was instituted. The last one, this is more likely. So anything after 1989, whether it's FHA or VA, it applies the same way. They have to qualify to the lender standard. If the loan is assumed, does the original borrower, are they still liable for it?
Yes.
Yes, absolutely. All right. Okay, NJIMFA. All right, so NJIMFA, this is the program. You need to know about it. It's awesome for first-time home buyers. It's designated for urban target areas, but other areas as well. It doesn't have to be inner city. It could be, suburbia, just not farmland. Let me phrase it that way. And this program can help people if they are short on money. Like they might have the deposit money, but they may not have enough money for closing. And so in this case, then they can get up to $15,000 free. All right, it's a grant. And so, but there's qualifications that you have to apply. What I can't find the right word. And the key is that you have to live in the property for 5 years. And then after 5 years, you don't have to pay for it. But if before the 5 years you sell your property, then you have to pay back the monies that were given to you. All right, it's an awesome program. I've used it. I've got lenders that use it. They also have so that's just the grant. That's the down payment. It's got another word for it, but that's that aspect of it. But they also offer loans. Again, you have to qualify for the income aspect of it. And their loans, their interest rates are a little bit less than the standard interest rate that's out there. So right now the interest is at 7.22 last I saw. And so they offer interest rates less than that, but it is specific to those areas. So like I live in Seabright. So they might have the NJIMFA for Ocean Township, and you can get a loan there and the lesser interest rate and everything, but it will not happen for Seabright. So they are specific to the area. And the money actually comes from the government. All right. So it's not even though we get it through a lender, the money, this program comes from the government, from the New Jersey government. The next one is the Farmers Home Loan. The newest word, this is the new word, okay, RECD. I know it as a Farmers Home Loan. This here, again, is for rural farm areas. Okay, again, you have to qualify for it. And you can get a zero loan, and the loan can be as low as 1%. And again, this money actually comes from the Department of Agriculture. So again, the money is coming from the government. All the other kind of loans that we've talked about come from lenders. All right, the lender is using their money, but here the government is giving the money, and that's basically it. All right, everybody good with that?
I have a question with the farmer's home loan. I did read it said first time home buyer specific.
Yes.
Is that?
Oh, yes, absolutely. Strictly home first time. Same with NJIMFA.
Okay. Okay.
Same with
All right.
NJIMFA. Yep, no worries. Okay, the next thing that we need to talk about is the primary and secondary market. So basically the primary market is where we, the consumer, get the money. All right, that's where we get the money. What is important, and the way they ask the questions. All right, so again, Gloria language. I always have my own language. So the secondary market has three little pigs. We have Ginnie Mae, Fannie Mae, and Freddie Mac. All right, so those are the three little pigs. And so basically you need to know what their specifics are. That's a good word. What their specifics are. So Fannie Mae is a shareholder-owned company, okay? And they are the largest purchaser of mortgages. So 1 out of 10 mortgages is purchased by Fannie Mae. But Fannie Mae also has specific guidelines, and those guidelines make those loans known as conforming loans. All right, so Fannie Mae only buys conforming loans based on their guidelines. So it's in the best interest of the banks and anybody else that's lending money that they follow the guidelines of Fannie Mae. All right, so that's the first part. Ginnie Mae is a government corporation. What they do is they buy low income, moderate income, and high risk mortgages. That's their favorite. That's their favorite food. Okay. And what they give for that is called a pass-through certificate. So basically, they're buying a share, investors are buying a share in a pool of mortgages. All right. They get a pass-through certificate that's guaranteed by Ginnie Mae. Okay. So that's Ginnie Mae. So their favorite food is low income, moderate income, and high risk mortgages. And then the last one, Freddie Mac. Okay. Again, shareholder owned. Their favorite food is savings and loan mortgages and primarily conventional loans. All right. And then they basically pool those loans and they sell bonds on the open market. Those are the three. That's the minimum that you need to know for the Three Little Pigs. Okay. And so all of this is conforming loans or based on guidelines, Fannie Mae's guidelines. A non-conforming loan is where it doesn't apply to Fannie Mae guidelines. It's not following any of that. And typically a non-conforming loan is also a jumbo loan. So now the greatest news since sliced bread in the last 3 years, maybe more, that Fannie Mae now is lending monies up to $1 million. FHA, sorry, not FHA is lending monies up to $1 million. So that means a jumbo loan is going to be 1.1 million or 1,099,000, right? So that would be considered a jumbo loan. And for that, you're going to go to a bank that does portfolio loans, meaning they're lending with their own money. All right. So portfolio loans are non-conforming loans. They can be jumbo loans. All right. And they're lending with their own money. And the reason they're called a portfolio loan is because the bank wants to show off the different types of loans that they have. So like they lent money to let's say a castle or to a geodome or something. It's just basically an easier way to remember. But they also help people that have unusual credit situations. So in this case here, we're talking about, if it's a business owner. So the business owner for tax purposes is showing zero monies, but in reality, they are making money. So that's an unusual situation, right? Because they're not showing money, but they have money. So that's that. The other word you need to know, because they're going to trick you on this, is purchase money mortgage. Okay. Purchase money mortgage is any kind of mortgage that you're using to buy a property. And again, if you read it backwards, it means mortgage money to purchase. It's a simplistic version. So do sellers give you purchase money mortgage if they're financing it? The answer is yes, if they're doing a standard finance, right? If the seller's going to take back the money and they're going to act like the bank, then they give you purchase money mortgage, right? The bank gives you a purchase money mortgage. Now, if we're talking about a land contract or contract for deed, then that's not a purchase money mortgage. All right. That's definitely seller financing. All right. Any questions?
No.
All right. So that's mortgages. I wanted to go through the Three Little Pigs. Here's the seller financing, right? So sale leaseback, all right, that is somebody who's got property, they have a lot of equity in it, and they also have a little store in this little strip mall. So what they're going to do is they're going to look for an investor who's willing to buy the property and then also allow them to lease back their little store, so that now the original owner got all the money out of the property, but now is paying rent to the new investor. All right, everybody good with that?
Yes.
All right. So Regulation Z is a part of Truth in Lending Act. So here we are with the laws. All right. And so in this case, then the Regulation Z, TILA and Regulation Z became TRID. That's where TRID has made that distinction that the banks must give a loan estimate within 3 business days, or that there's got to be 7 business days in between before the closing disclosure could be sent out 3 business days before the closing. All right. So those are the laws on that. All right. What else? Okay. So that takes care of those important ones. All right, let's go to New Jersey law. Okay. So, the New Jersey Real Estate Sales Full Disclosure Act. All right, that's usually one that everybody gets mixed up on. So basically here, what we're talking about is we're talking about out of state land, right? Let me just see if I can make it bigger. Okay, there, you can probably see it. Too much. All right, so we're talking about land that's being sold to us in New Jersey from out of state, like North Carolina, Florida. Okay, we're talking about subdivisions. We're talking about condominiums and cooperatives. Okay, and then we're also talking within the state properties that have 100 lots or more, or they have common elements. So common elements typically means homeowner association or condo association, right? Yes, no, maybe?
Yes.
Okay. All right. So before any developer can sell any kind of property or start building any kind of property, all right, they have to register with the Bureau of Subdivided Land Sales, which also means that this Bureau of Subdivided Land Sales is controlled by, or not controlled, administered by the Real Estate Commission. All right. So that means any new development of any sort is going to be registered and approved by the Bureau of Subdivided Land Sales Control, which is administered by the Real Estate Commission. All right. And if this is an out of state, let's say North Carolina, we went on a trip down to North Carolina. And as we're driving around, we saw a developer developing land. And the guy said to us, hey, we were started to talk, and the developer says, he says, I've been wanting to sell to New Jersey people because they go down to Florida and then they come halfway back up and they buy in North Carolina or South Carolina. So you tell them that they're in luck because you are a licensed realtor. And so what are you going to tell them? You're going to tell them that, yes, I can sell your property in New Jersey. However, you must file and register with the Bureau of Subdivided Land Sales Control. They're going to come check it. You have to give them your POS, public offering statement, and they're going to check everything. And if everything is good and you're approved, then you're going to have to hire a New Jersey broker. And you're in luck. I'm a New Jersey broker. I'm a New Jersey licensed salesperson. I work for a broker. And so therefore, I will be able to sell your property. All right. Everybody good with that?
Yep.
All right. Okay. The other aspect that you need to know is that if you are advertising a property, now advertising takes any kind of form, doesn't matter what it is. If you're advertising in a language other than English, then all of your forms, now we're talking about property. We're not talking about a list. All right. We're not talking about a generalization. We are talking about a specific property. 123 Maplewood. All right. So I am advertising 123 Maplewood in Brighton Beach, New York, Russian community. They don't speak English. So I'm going to advertise in Russian. All right. If I am going to be doing that, then any forms that apply to that property is going to have to be translated into Russian. All right. And if we get into a transaction and everything, we're going to have the paperwork in Russian followed with the paperwork in English. All right. But if I was going to be advertising 123 Maplewood in Brighton Beach in English, then I don't need to worry about that. Okay. Now, new construction, how many days do they have to back out?
3. No.
10 days?
Nope, that's a guess.
Yeah.
7 days, ding, ding, ding. And it's 7 calendar days, but you don't need to remember calendar. It's 7 days. So that's new construction. Does that apply to properties that are out of the state of New Jersey?
No.
Yes. All right, new construction out of the state of New
So-
Jersey, new construction in New Jersey, they have 7 days right of rescission or basically backing out. Okay. Now, in new construction, do they have additional time to check out off-site conditions? Do we know what off-site conditions are?
The area surrounding,
Good. And what is it about the area surrounding that we're concerned about?
if it's near a factory or
Good.
it's-
Good. If there's hazardous waste or a landfill. All right. So the answer is with new construction, yes, they have an additional 10-day opportunity to check out the off-site conditions. Does a buyer on a resale property have extra days for off-site condition? No. The answer is no. All right. Does a buyer have the right of rescission on a mortgage on a resale property?
they say yes.
No.
No, it's no.
Do you want to guess why? Okay, you know what? There's 20 people here. I expect some answers from others as well. I'm going to start getting on my bandwagon. So, why would a buyer on a resale property not have the right of rescission on a mortgage?
Right, I don't know. I'm
Because
sorry.
it's contingent on the agreement of sale.
Is it contingent upon the agreement sale? Yes, because we have a contract. We're out of attorney review. And in the contract, it states that they have to have a mortgage. So they can't back out of a mortgage. Thank you, Sierra. All right, so that's very important. They do not. Now, as a consumer, on any financial agreement, do you have the right of rescission of 3 days?
Yes.
Yes, absolutely. All right. Those are the two differences. So on a mortgage, on a resale mortgage, they do not have the right of rescission because we have a contract. They stated that they needed a mortgage to buy the house. That was in the contract. And so therefore they can't back out. Now, of course, if they lost their job, that's a whole different story. All right. The New Jersey law of discrimination. All right. Is that the strictest law that we have to abide by?
Yes, probably.
Good job. And is there one that could be stricter?
Taxes?
Taxes? No. Anybody else?
Regulations.
What was that, Hernan?
Regulation, like the regulations Z.
Oh, no, that's all a part of it. So, no, the answer is the only thing that can make it stricter is the municipality law when it comes to renting. Okay, so that's the health and welfare. So, certain municipalities may have laws on restrictions on people per square foot. Okay, So let's just say you're renting a studio. I know nothing about square feet, so I'm going to give you a ridiculous number. So for 580 square feet, the municipality law states that you can only rent it to one person. So therefore, that is stricter than our NJ LAD. Okay. And therefore, you would have to abide by the municipality law. All right. So that would be the strictest law. But for us in general, any other laws that we have to abide by, which we have to abide by, give me some laws that we have to abide by.
Fair housing law?
Fair housing. Okay. NJ LAD is stricter than that. What else? What was that?
Disability.
I can't understand you, Vanessa. Your machine isn't working too good.
She said disability.
Disability law. Okay. Well, we're stricter than that. We don't have a specific disability law that I know of. I know it's ADA, but that
Megan's
that-
law.
Megan's law. Okay, again, we're stricter than that. That's a part and parcel to that as well. All right. So the one I was thinking about was the Civil Rights Act of 1866. So New Jersey law is stricter than that. Fair housing law, New Jersey is stricter than that. If we were in a state where the state law was let's say less than the Fair Housing Act, then in that state the Fair Housing Act was the law that we have to abide by. Okay. So the key here, where I'm heading to, is that we have to abide by the strictest law that we have, and for us in New Jersey, it's NJ LAD. All right, that's the strictest law, and no matter what, we have to abide by that. All right, so we have race, creed, color, nationality, gender identity, marital status, civil unions, familial status, pregnancy, breastfeeding, affectional sexual orientation, disability, there it is right there, source of lawful income, and liability for military service. All right, so these are all the main items that NJ LAD has. And as far as the fair housing, it has race, creed, national origin, race, creed, color, national origin. They added familial status to that, but that's the basics of it. All right, and then so what I'm going to do is I'm going to show you I put together an Excel spreadsheet when I was studying. So this is how it breaks down, and again, it kind of helps you along the way. Okay, so Civil Rights Act of 1866. Never discriminate on race and color. Never, ever, ever. All right, that's where we had the Jones versus Mayer lawsuit that brought this about. Property covered. When we say all property, that means residential and personal property. That means even the clothing on your back is protected by the Civil Rights Act. Okay, lenders are not covered underneath that. There's no exemptions. There's no provisions. It goes to the federal court. So you're going to sue in the federal court, and that's the main part of that law. All right. The Federal Fair Housing of 1968. So again, we can't discriminate against race, color, religion, national origin, sex, handicap, and familial status. All right. Now, Federal Fair Housing, what kind of property does that apply to?
Residential.
Thank you, Nancy. Ding, ding, ding. Residential only. Okay. Does it apply to lenders? Yes. Only institutions, banking institutions. All right. Now, the owner. All right. So for a sale of a single family dwelling, is there an exemption for the owner to sell their property and discriminate? The answer is yes. Okay. As long as there's no broker involved and there is no discriminatory ads being used. All right. Again, if we're renting it for 1 to 2 family, okay, again, if it's owner occupied and they didn't have a sale within the last 24 months, the answer is, again, not using a broker, they can discriminate. All right, never on race and color. At minimum, never on race and color. This is where it's different from NJ Ladd. Okay, so for a rental of a 1 to 4 family, again, the same thing applies. Owner occupied, no broker, no discrimination, ads, etc. Okay. Exception for housing restriction, no. Exemption for religious organizations, yes. So a religious organization, again, not using a broker, they can discriminate to the religion that that religion is, whatever that might be. All right. Talking about private clubs, private member clubs. The answer again, under fair housing, yes, they can rent out to their own club members and not allow other members to, other people to rent any lodgings that they have. Denial of entry into MLS. Yes, the fair housing says we can't deny any broker from allowing to represent their properties on an MLS. All right. So now, if a discrimination occurred or they felt that it was occurred, all right, they have 1 year to complain to HUD because that's who's in charge of the fair housing. Okay. And then if they want to make this into a federal lawsuit, meaning going under the Civil Rights Act, then they have 2 years to make that complaint. All right. What here, you don't need to remember the fines because the fines are weird numbers. Every other fine that we have in all our license laws and everything end up in 0, 0. Okay. But here, every other fine for a fair housing has a weird number. Okay. So in this case, then you don't need to memorize those numbers. Okay. And again, what you need to know as well is that the Federal Fair Housing Law is also called the Civil Rights Act of 1968, Title 8. All right, so that's all the wording to that. So they might refer the Fair Housing Law as Title 8. Okay, everybody good with that? Are we alive?
Yes.
Thank you.
Yes.
Right. I want you to know this because you don't know where they're going to ask you. And laws are very, very important because that's how we can get into trouble.
Yes.
Okay, so now let's talk about NJ Ladd. So again, we have race, color, religion, national origin, sex, handicapped, familial status. Again, familial status here applies to rentals for New Jersey Ladd as well. Okay. Marital status, nationality, ancestry, affectional and sexual orientation, source of income. All right. Especially for rentals. The Attorney General Memorandum, which is the New Jersey Law Against Discrimination written by the Attorney General, has actually made it extremely clear and evident that Section 8 people, government subsidized people that get income from government subsidies cannot be discriminated against just because they're getting government money. So that's very, very important. And that's in the Attorney General Memorandum. And again, our law protects everything, all property, residential, commercial. I don't believe it covers personal property, but it's commercial and residential 100%. The law covers all lenders. Now, all lenders means private people that are lending money. All right. Now, what is considered a private person that lends money? They have to lend it at least 5 times a year and get monthly payments. They are then considered a lender. And especially if they are using a house as collateral when they're lending money, then they come under the law as well. All right. So it's not just institutions, it is private individuals as well. Now, here under NJ LAD, we don't have an exemption for the sale of a single family home. Fair housing does, but NJ LAD does not. And here, this is where the only exception that we have, again, is similar to fair housing. So if the owner occupies one unit, they can discriminate against who they want to live in the other unit. New Jersey law is only for 1 to 2 family dwelling. All right. It will not apply under NJ law for 1 to 4 family. All right. So that exemption is only for someone who owns a 1 to 2 family house. All right. Not 1 to 4. And again, we're talking about they're not using a broker, they're not advertising, etc. There's no housing restriction, but again, religious organization, yes. The private clubs, no. There's no provisions regarding the MLS, but if there was a discrimination, then they have 180 days to file with the Attorney General. Okay. And then the Division of Civil Rights will investigate it after 45 days, and then they will do whatever their orders are, cease and desist or whatever it is. All right. And so then the first offense, okay, is $10,000. Okay, so this is NJ LAD, not license law, NJ LAD. The first offense is $10,000, and it could be as high as $50,000. All right. If you're not helping out and you're hindering it, you could be fined $500. Okay. And our laws apply to rentals, not just sales. And if the owner owns a property that has 25 units, like an apartment complex, all right, they must send reports to the civil rights about the mixture of people living in those apartments. And so they have to send that report every year. So that's NJ LAD. Okay, how are we all doing?
Okay.
We're alive?
Good.
Yep.
Still here.
Yep, we are.
All right, good. All right, so that takes care of NJ LAD. All right, let's see, what else do I have here that we need to go over? We talked about all of that. I did that in my short form. All right, yes, let's talk about lawful income. Again, with the Attorney General memorandum, you cannot refuse if they're getting monies for Section 8. You can't. And some big companies, I want to say 2 years ago, if I remember correctly, they were sued because their agents stated in the phone, and it got recorded, and I don't know exactly who found out about it, but it was recorded that the agents stated that their owner will not rent to Section 8 people. All right. And so not only did the agents get into trouble, but the corporation, the big, like Cochrane Group, Coldwell Banker, Sotheby's, big corporations got sued, and they lost, needless to say. All right. So very, very important. We cannot say the landlord only is looking at tenants with 720 credit score, FICO score. It used to be that people would do that. We're not allowed to do that. And you'll get into trouble if you do that. And again, the other part that you need to know is that the Fair Housing HUD, right? Fair Housing HUD and the Real Estate Commission hire volunteers people who don't get paid, and they are volunteers to check on us realtors. All right. So I don't know who I'm talking on the phone unless I've talked to them several times. I have no clue who's calling me up and asking me questions. And so I am never going to say anything about anything. I'm just going to listen to what they have to say and then send them whatever information that they're asking. But I will never say, oh no, my landlord, doesn't do this, doesn't do that, wants only this, wants only that. Because you don't know who is on the other side. All right. And believe me, these testers enjoy doing it because they're volunteers and they're not getting any money for it, but they enjoy catching people. All right. And then the newest of the new is that the Real Estate Commission has hired quite a few younger people that are very well versed on the internet. All right. So again, we're back to we don't know who's sending us emails and questions about property. So again, be very cautious and careful as to how you answer those emails that you get. All right. And if the owner tells you this is the way it is, blah, 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 depending on how, discriminatory that person is, I'll walk away. I'm not going to lose my license. I worked way too hard. I have 3 licenses. I worked way too hard to get penalized because somebody doesn't want something. Let them go do it on their own. All right. So very, very important. I read a very interesting lease the other day for a client of mine, and it said that the landlord refuses children being born in the house. And if they are born in the house, then they have to register the child. I thought you weren't allowed to do that, but apparently someone, because I asked that question, but apparently they were using the health and welfare law to protect themselves. So again, you can't refuse to rent to families with children or people who are becoming pregnant or whatever the case may be. But again, which is the strongest law? In this case, the municipality's law is that they need to register every person that is living in that unit because it's a rental. Okay. Then they have the right to state that. All right. The other thing is you can't rent a 1-bedroom apartment and say that 2 members of the same sex cannot rent that apartment versus a man and a woman can rent that apartment. So if it's available to everybody. Okay. Service dogs. Okay. Service animals. So again, it's a very big deal. And you have to be careful about it. So service animals are not pets. They have a job and they do a job. So we cannot discriminate against them. All right. But let's just say this person with the service animal, let's use it that way, has terrible credit, has not been making their payments on time, and they have, let's say, a 500 FICO score. Can I tell them that I will not rent to them?
Yes.
Yes, right? Because I'm basing it on income or on their credit, their credit and their ability to pay back. And the answer is their ability to pay back is not very good. So therefore, I don't have to rent to them. Okay. Again, the key here on things like that, your best bet is to talk to your broker, okay, to find out how they handle that. Because again, there's new situations happening regarding using credit reports, what they're called tenant reports, and they have different situations. So you really need to ask about that from your broker. And your broker is going to tell you how to handle it, what to use, what not to use, et cetera, et cetera. I will tell you that right now, rentals is the hottest thing on the market right now. So if you can get into doing some rentals, I will tell you, by doing rentals, you'll get money right away. By doing a sale or a listing, you have 3 to 4 months before you get monies. But doing a rental, yes, it's a pain in the ass. Yes, it's the same amount of work as a sale. All right. But you get monies immediately. You get paid immediately. All right, real estate guarantee fund. Who controls the real estate guarantee fund?
Real estate commission?
Ding, 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 ding. Okay, where do they get the money from?
The salespeople and the broker on their first application for their license, $10 and 20 or I don't know.
Bravo. Okay, good job. All right. And what is it? What's the reason that it's set up?
It acts as a guaranteed if something bad should happen, and I am at a loss right now, so
They insure any losses, I think, a seller or buyer induced with dealing with a neglectful or company's realtor.
Okay. So, in other words, if they were defrauded or something bad happened to them, all right, then in that case they have the right to sue. All right. So the key you need to know is how must it be done. All right. So the guarantee fund, the person that was hurt, let's call it that way. I can't think of another name. So the person got hurt, the consumer got hurt. So what must that consumer do? The consumer must file for a judgment, and the consumer then must try to get to collect monies from that judgment. If they are not able to collect monies from that judgment, then they are going to file a criminal claim, and they are going to include the real estate commission as part of that lawsuit. All right. And then they have up to 6 years to collect and claim from the guarantee fund. 6 years. Why? Because that's the statute of limitation for us to get sued. All right. The maximum payment is $20,000 per offense or per claim. And the individual that the licensee that did this terrible thing will lose their license. All right. And they could potentially get their license back if they reimburse the guarantee fund along with the interest, but they may also they will have to show remorse. And again, the New Jersey Real Estate Commission may or may not give them back their license. All right, everybody good with that?
Yes.
Okay.
So that's like a second defense. Like you said, they would have to go for a judgment, and then if that's not satisfied, then they would go to the commission and towards the fund, I guess.
Well, they're going. Yes, that's correct. But they're going to, no matter what, they're
Okay.
going to. No matter what, they're going to name the real estate commission in the judgment and in the criminal.
Oh, so they will be okay.
Yeah, they have to because then this way the real estate commission will know that there's something happening.
Okay.
All
Puts them
right?
on the map so know what's going on. Got it. Thank you.
Exactly. Yep, exactly. All right. So now the Real Estate Timeshare Act, it's now got another name to it, which I can't figure out what it is, but I'll look it up right here. It's time sharing law, I think it's called. Time sharing law. I think that's what it's called. Timeshare law. Okay. So it applies to any timeshares that are outside of. So here's the key: the timeshare law applies to timeshares that are outside of New Jersey, okay, but they are being sold in New Jersey. All right, that's the key. So it's a Disneyland, Disney World, whatever, blah, 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 world, timeshare, Atlantis. They're selling it in New Jersey. I don't know where, it doesn't matter. Okay, so we're selling it in New Jersey. It comes under the Bureau of Subdivided Land Sales. All right. And again, because it's out of state, but we're writing the contract in New Jersey, they have a 7-day right of rescission for that contract. All right. So if I decide that I'm no longer interested in it, I have 7 days in which to cancel this contract because this contract was written in New Jersey. Keyword. Okay. Now, if I'm in Florida buying a timeshare in Florida at Disneyland or wherever I am, All right. That law will not apply to me because I am in Florida and I'm buying it there. Even though I'm a New Jerseyan, I'm in Florida and I'm buying that timeshare there. So that law does not apply. I have no rights regarding that. Okay. And so if I canceled, again, the key word you need to know, the seller must refund all payments, deposits within 30 days. All right. So that takes care of that. Are we all good with that?
Pretty good.
All right, good. So now let's go to the other laws. All right. So advertising, what must you have when you're advertising?
Brokers,
Business name and office phone number.
Good. What else?
Municipal office address.
Okay, good. What
Brokers information.
Okay, the broker information. So in this case, would a logo be an example of that?
I think it has to be the specific name.
No, broker logo can be used.
Okay.
Broker logo can be used. All right. If you're not using the logo, depending on where you're advertising, etc. All right. You might not want to use a logo. You might just want to put the broker's name. Now, when we're saying the broker, are we talking about the broker of record or are we talking about the broker business name?
broker business.
The business name, right? So Sotheby's, right? Or Remax. Okay. So that's what we're putting down. We're going to put down the office number. Do we have to label that office number? Like with an O or a B? Or the word?
Yes.
Yeah.
Okay, good. All right. Are we allowed to put our cell phone number on there?
You can.
Yes. And we have to label that? Yes.
Yeah.
Yes.
Okay. Can we put our email out there?
Yes, we can.
Okay,
With the name.
good. With our name on there. Okay, good. Can our name be bigger than the brokerage name?
No.
No.
No. Do we have to state what our license is?
Yes.
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 Yes. Okay. Again, if you're an internet, guru and you want to make up your own website, then the key is it's your website. You've designed it, blah, 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 blah. You have to make sure that you have a link that links back to the brokerage website. All right. If you're a fancy schmancy IT kind of person. If you're just a regular person, then and the brokerage company says, look, we're giving you a page on our website, blah, blah, blah. You don't have to worry about it. And basically you'll just have your picture, your information, et cetera, et cetera. All right. So those are the main things. The next thing is if you are, all right, I'll finish this and then we'll take a break. I just noticed. Where was I here? Let me go back to, oh, yes. Okay. So if you are deciding to send out letters to a development or whatever the case may be, right? And you decided you're going to send out letters that says all the sold properties in the last month in this development, okay? Quaker development. If you're spitting out the information exactly as you see it on the screen, then it's not a problem. You can add your own stuff to it, whatever you want to do with it. But if you're spitting it out exactly as you got it off of the MLS, then it's not an issue and you just mail it out or do whatever it is that you're doing. But if you decide to fancy it up, right, by making it into a graph or a pie chart or something to that effect, then you're always going to have to put in where you got that information from. All right. So I belong to Monmouth Ocean Regional Realtors MLS. So I'm going to write down that information is deemed reliable, but not guaranteed from MORR, MLS, and today's date. All right. Because I made it into a pie chart and all of this, and I'm making a fancy postcard. And so, based on that, I have to tell the world where I got that information from. But if I just spit out the list, then that information will automatically be there, and it doesn't matter. I'll just put it in an envelope and send it off. All right. Everybody good with that?
Yes.
Makes sense?
Yes.
Yeah.
Yeah.
Okay, good. Thank you. We don't advertise dollars and cents or interests or anything along those lines. But as far as the state is concerned, if we were to do that, those would be called trigger terms. So if I said, oh, this house, the mortgage is $1,500 a month, then that's a trigger term. Then I'm going to have to explain how did I come up with this $1,500. So I'm going to have to say how many years it is, what is the down payment, what is the interest rate. If I put in just APR, that would cover everything else that I have in there. So I would not have to put in that. But what I would have to put in is that to a qualified buyer. Okay. You must always put that in there. Like I said, most of the time realtors don't put in dollar amounts or interest or anything like that. That's why we have affiliations or friends with the lending department. So that would be basically that. We're not allowed to do free drawings or any kind of inducements to make people do business with us. That's against the law. We need to make sure that if we're going to be talking about commissions, although nowadays you all know about the lawsuits, I'm not going to go there. But again, all commissions are negotiable, and you better make sure that everybody knows that. Okay, very, very important. All right. And so let's take a break. I'll see you back here at what, 10 till 5 till.
Okay.
All right.
Thank you.
You got it.
Thank you.
You're welcome. Oh, okay, I'm doing it now. I just did it now. Okay, so one of the choices that we have, thank you for reminding me. One of the choices that we have then is, okay, Mr. and Mrs. Buyer, I'd like to negotiate. You are paying me a commission. All right. So I work for 3%. Are you willing to pay my commission for 3%? And then this is what I do. Blah, 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 blah. There's much more than what meets the eye, Mr. and Mrs. Buyer. And da, 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 da. Okay. And Mr. and Mrs. Buyer says, well, we just barely got the down payment. How the hell am I going to pay you your commission? And 3% on top of that. Well, Mr. and Mrs. Buyer, these are all the things that I do. So we have a choice. We have a choice that we can try to negotiate with the seller and the seller's agent that they will pay for the commission, but we would have to put that in writing when we make an offer to that property. Or the other option that we have is that I will only show you properties where the seller is offering a commission. Now, in Gloria language, okay, to me, that now, in Gloria language, that now to me means steering. Would you agree?
Yeah.
Right?
Yeah.
But if the buyer isn't going to pay me my commission and the seller is not going to be paying my commission, I'm certainly not going to be working for free. So then the only option I have is to find sellers that are willing to pay a commission. So that's the basics. That's where we are right now. Do you have further question on that or further?
No, thank you for the
detail?
clarification.
All right. So the key is going to be, in general, me included, I don't like to sign anything. It's as simple as that. Buyers don't like to sign anything. So you guys, especially you guys now, right? More so than me, but you guys right now are going to have to put together a list of the things that you are going to do for a buyer. So as a listing agent, I have what is a marketing list, right? What am I going to do for the seller? Well, for the seller, it's all about marketing, right? So I'm going to pay for the photos. I'm going to pay for the video. I'm going to pay for the drone. I'm going to pay for sending out mailers. I'm going to advertise on Facebook. I'm going to advertise on Google ads, whatever the case may be. And then I'm going to negotiate the contract. I'm going to blah, 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 blah. I have a plethora of things, about 264 items on my list, which they never go through. I could certainly take that same list, turn it around and make it my buyer presentation. Okay. So maybe instead of 264, I might have 244. And use that as my presentation for the buyer and say, okay, look, I don't work for free. There might be agents out there. I don't know. I don't think so. Because we're paying for our car. We're paying for the gas. We're paying for our time. And I'm not going to be driving around and showing you houses all over the world and not get paid for that. So I'm not asking you to pay for it now. But I could negotiate a fee. I could say, okay, so for the first 3 houses, I'm not going to charge you anything because this way I'll be able to get to know you better. You'll get to know me better. So I might do a freebie. All right. 3 houses. Whoop-de-doo. Okay. And then after the third, now that's where your documenting becomes very, very important. Okay. And so then after the 3rd house, I now have a good idea of what you're looking for, what your price range is, what you're willing to do, not do, blah, 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 blah. So now what choice is you're going to pay me a commission, or we can talk about a flat fee, or we could talk about an hourly rate, or. Okay. And that's basically where you're going to be. Then the next thing that you're also going to be talking to them about is, are you going to put a deadline, a timeline to this agreement? All right. Now, understand, I would tell, if I'm in that position coming forward, right, I would tell them that I need to have this in writing because this is the law. And it is the law, right? If they don't like it, too bad, go someplace else. All right. It's full disclosure. That's the way it is. So this is the law. And in order for me to help you with your real estate project, whatever the word is, I need you to sign an agreement. But understand that I have no problem that if you no longer want to work with me, that I will terminate the agreement. However, it will have to be in writing. That's it. So if 24 hours later they find that I'm too intense, that I have sailor language, et cetera, and they don't want to do business with me, I have no problems letting them out, but they better put it in writing. And that's basically right now the simplistic version. Now, again, you have to understand, you will have to follow what your brokerage company is, setting down as the law. Everybody good?
Yep.
Yes.
Okay, any questions? Any thoughts? All right. The other thing that you're going to have to be very, very seriously cautious about is when you're dealing with a buyer, you're going to have to ask them, do they have a buyer agency agreement with another realtor? Because an agreement, is that a contract?
No.
You're kidding me, right?
Sorry.
An agreement is a contract. Are we putting it down in writing?
Yes.
Yes.
Right? Are they signing it? And I'm signing it?
Yes.
Yes, it's a contract. So they have a contract with another agent. We don't know what their agreement is as far as termination. I can't pretend to know what they have set up. But if I find out that this buyer has a buyer agency agreement, all hands are off as far as I'm concerned, because they have a contract. Okay. So that's very important. That's going to become now a very important thing. Just like when we would do open houses. All right. This is going to be another thing that's going to happen with the open houses. Before this situation, when we did open houses, we would always ask, are you working with another agent? Okay. And a lot of times the public knew that if they said yes, that they were working with another agent, all hands off that buyer. All right. But now it's going to be, that was just verbal, right? But now this is going to be on paper in writing. And is that buyer agency agreement, that contract, is that enforceable?
Yes.
Yes, absolutely. So theoretically, again, I'm not a lawyer or anything like that, but theoretically, let's pretend I took that buyer out. I didn't ask that stupid question. I didn't ask that question because I was stupid. And I took that buyer out and I showed them the house and they loved it and everything. And then they turn around and they say to me, oh, Gloria, we have a buyer's agency agreement. Who's going to get paid?
Not you.
Not me. Definitely not me. I showed the house, but I don't have a contract agreement. I wrote the contract. They love the house, but who's going to get paid? It's going to be that other agent who didn't do anything, but they had a buyer agency agreement. So that's very, very important. That's definitely part of contract law. All right. Everybody good?
Yep.
All right. Okay. So let me ask you a question because I got nasty on an email. I shouldn't have, but I did because it annoyed me. How do you get your license?
You have to have 70 hours of in-school training, I think
Well,
it is.
first off, it's not 70, it's 75.
75.
Yes.
Okay, good.
75 hours of school, and then you have to pass the school exam. And then
Okay.
you have to pass the state exam.
Okay.
Then you have to get fingerprinted.
Okay.
And then you have to be hired by a broker.
And how do you get the license then?
The broker has to.
Thank you. All right, good job. All right. The broker is the one that gives you the license. All right. Taking the course, passing the course, taking the state exam, passing the state exam, taking your fingerprints does not give you the license.
Okay.
Right? It's signing on with a brokerage company, and it's that brokerage company that is giving you the license. All right? Very, very important. The person that I was nasty to was saying that they did their fingerprints, they did everything. Now they're looking for their name in the real estate commission and they can't understand why it's not there. Okay. So the answer is the brokerage company that you sign on with is the one that's giving you your license. Very, very important. Now, can you transfer easily to another brokerage company because you decide you were here 3 months and you hate the person?
Yes.
Yes.
Absolutely. All right. That's a lot easier than getting your license because initially, although things may have changed, I'm not on the admin side, so I don't know 100% about that. But I believe that on the admin side for the initial license, it's still snail mail, certified snail mail. Okay. But on transferring from one company to another company, that's done on the internet. Okay. And so you go to broker A, that's your current broker. You say, look, I want to get out of here. So broker A says, no problem. They do whatever they do on the back end. And then you then go over to broker B and you say, okay, broker B, I quit that. I want to be with you. And they'll do whatever they got to do. And now you're with broker B. You are going to pay a fee. All right. The real estate commission wants to make money. And so you're going to pay, I believe it's a $50 transfer fee. All right. But no big deal. Okay. So how much is your license as a salesperson?
$160.
Ding, 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 ding. Okay. When you're signing on with a broker through an independent contract agreement, do you have a contract with the broker?
Yes.
Good. Have you started the law of agency with the broker?
Yes.
Do you owe fiduciary duties to the broker?
Yes.
Are they your client?
No.
Yes.
Yes.
Yes. They are your client. You sign an agreement to work for them. You work
But I thought
for
they,
them.
I thought that you would be their client. No.
Who would be the
You
client?
work- You as the agent,
Who's paying you?
the broker.
Okay, so therefore they are your client. You are working for them, right? If I have a listing, who's paying me? I'm the broker. We have a listing. Our office has the listing. Who's paying me?
Your broker.
No, I'm the broker. Our
Oh.
office has the listing, right?
Oh,
Who is
the
paying me? The seller,
The
right?
seller.
So the
Yes.
seller, is the seller my client or my principal?
Yes.
Okay. So I am the salesperson. I've signed on with the broker. Who is paying me?
The broker.
The broker. I am therefore working for the broker. I am working for the client. If I don't, again, this is Gloria language. This might help you too. Gloria language. Now, disregard agreement. Agreement equals contract in Gloria language, means that in real language also. But contract, it starts with the C, it ends with the T. Client starts with the C, ends with the T. If I have a client, I have a contract. If I have a contract, I have a client. If I don't have a contract, I have a customer.
Okay.
Did that help?
Yes.
Yes.
Okay. All right. So I am working with the customer, right? I am working for the broker, but I am working with the customer. And what do I owe the customer? I owe them honest and fair dealing, but I don't owe them any legal responsibilities or legal fiduciary duties. Okay. Now understand that fiduciary duties are legal responsibilities, and I can get into trouble for not doing my legal fiduciary duties. All right, so you have to remember that when you have a contract, we now have a legal situation. This is not a it's a legal situation, and it could get sticky or it could just go very smoothly. Okay. A listing agreement, that's a contract, correct?
Yes.
Good. On that listing agreement, what makes it a contract? What is a valid contract? What makes a valid contract?
Acceptance.
Signatures and expiration.
Okay, signatures,
Acceptance.
Consideration.
consideration. So far I have signatures,
Value.
consideration, value. Okay.
And the expiration date?
Oh, thank you very much. Ding, 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 ding. All right. So a valid contract consists of a beginning date and end date, a legal adequate description of the property. So for us, a legal adequate description of the property would be block and lot number. All right. We would have the address also, but the legal adequate description is a block and lot number. We would then have the value, what are we going to be selling it at? And the consideration is what am I going to get paid? And again, the signature that all parties have agreed to that. All right. That is a valid contract. All right. So that could be a contract as far as a listing agreement, or that could be a contract to purchase. Now, are there other items in a contract to purchase that we would have on there,
Yes.
such as?
I mean, not necessarily, there could be.
Could be.
Um,
What would we have on there? What could we have on there?
um, would anything
have
that
some
the, like,
Go ahead.
I'm
No, go
sorry.
ahead.
No,
Permission?
I was going to ask,
Go ahead. What were you going to ask, Lavada?
I was going to ask, if, like, if someone likes my furniture, I'm selling my house and someone likes my furniture, would that be in a contract or that's separate, right?
That's separate. Okay. So,
Okay.
Gloria language, I sell real estate. I don't sell furniture.
Mm-hmm.
Right.
So that would be
So,
like, yes.
So that would be a separate document, but I might write that in my contract just in case they don't write some, just in case the two parties don't write something separate. So I would say that the buyer is very interested in the furniture, whatever furniture it might be. So anything that's not in the contract, I would add that to the contract so that this way, why? It's in writing. Is it enforceable?
Yes.
Yes.
Yes, right? So if it's in writing, it's enforceable. So now let's just say we have a listing agreement, and in the listing agreement, it states that all right, in the listing agreement, it states that the seller is going to be, when he leaves, he is going to be pulling up all the iris flower bulbs. All right, that's the listing agreement. Right? That's not a normal thing. So I would want to make sure that I put that in the listing agreement. Would I also put that in the MLS?
I don't think so.
Oh, absolutely.
Oh. I'm not doing well.
Absolutely. Why? Because if the buyer sees the irises are missing, they're going to question it, right? But if it's in the MLS listing, then they'll know that, okay, those irises are not staying, right?
Yeah.
Or trees. I mean, I've had trees taken out. All right. So whatever the seller is going to do, you want to make sure that you document that into the listing agreement. And if you have to write up a separate piece of paper, a lined, notebook piece of paper, I don't care what it is, right? If it's so verbiage that you get a notebook piece of paper and just start writing it down. You can always scan it. That's not difficult. All right. And then that will be part and parcel to your listing contract because that's really what it is. All right. So now let's move forward. We now have a buyer. So we put in the MLS that the iris bulbs are excluded. Okay. So we have a buyer and we wrote a contract and we're going to use just what you just said. We have a contract and the contract got accepted. They went back and forth and everything. And now the buyer moves into the house. Okay. And they notice that the irises are not there. Okay. Whose fault do you think it is?
the buyer for not reading the contract that states they're going to take it?
The buyer? No.
They-
The buyer is the one that's upset.
Right, but he's the one that bought it, and if it's in the contract, he could have
Well,
read
wait,
it.
Did I say it was in
Buyer's
the
the
contract?
buyer's agent.
Buyer's agent, right? The buyer's agent did not put the exclusion in the contract.
Oh.
Who else is at fault?
You didn't sell it.
Who else is at fault? There's a second person that's at fault.
The seller?
The seller's agent. Okay, the seller's agent is at fault. Why? Because they didn't read the contract that the buyer agent sent them. Had the seller's agent read the contract, would they have noticed that those irises are not included in their contract?
If they read it, yes.
If they read it,
Yeah.
right? Is that your fiduciary duty as a listing agent?
Absolutely.
Yes.
Absolutely. So who's going to be at fault at this point? It's probably going to be both agents, but more likely the seller's agent because they didn't read the contract. Because had they read the contract, they would have caught the mistake that the buyer's agent did. All right. So that's fiduciary duties. That's a legal obligation. All right. The same thing if it was a crystal chandelier. I call it grandma's crystal chandelier that was excluded from the sale. Can I exclude a crystal chandelier from the sale?
Yes.
Absolutely.
Absolutely.
Absolutely. I can exclude anything that I want as a seller. Maybe not the best thing, but I can exclude anything that I want within reason, right?
Mm-hmm.
So in this case, the same thing. If the buyer's agent didn't put it in and the seller's agent didn't read it, I could be basically, I'm the seller's agent. I mean, how much is that chandelier? It could be $100,000. I don't have that kind of money. I'd be in deep trouble. Right? So again, it is our duty, no matter who we are, listing agent, buyer's agent, it is our duty to read everything. Right? That's what fiduciary duties are. We're protecting our client, or we're educating our client, or a combination of both. All right. So if you terminated, you decided to move from one company to another company. All right. What must your original company do? Original broker do?
Pay money.
Take money?
Pay.
Oh, pay the money?
Pay
Well,
the money.
Is money due? I don't know. The
If
answer,
money is due.
the answer is you have to give an accounting of any money that is due. Obviously, if I'm leaving today and I'm owed a commission, they'll pay me that commission. But what happens if I'm leaving business behind? That's not the intent. You try not to do that. But let's just say you did. What kind of monies that will be owed to me if it goes through? What kind of an item would make the broker owe me money?
Close sale after you leave the broker.
Ding, 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 ding. Good job. All right. So will that be a listing agreement? Because is there a contract on a listing agreement? No. But if I left behind contracts, I left behind listings that are under contract, then that broker owes me money. All right. So then in that case, they have to send me a written accounting within 30 days, keyword, 30 days of termination or leaving, whatever word they want to use. Okay. But when the agent left the brokerage company, the broker has to give them a written accounting within 30 days. That's the key. Okay. My broker died. Okay. And I am a salesperson that has 2 years experience, and there is no other broker salesperson in the office. Can I apply for something?
Yes.
What can I apply for?
The broker salesperson license?
No, that's not what it's called.
A
Temporary,
temporary,
temporary brokers.
That's what it's called. Temporary broker's license. And within how many days after the broker's death?
Ten?
No, that's a guess.
Isn't it right away?
All right, within 30 days. All right, so within 30 days of the broker's death, I can apply to the Real Estate Commission for a temporary broker's license, which means then the office could stay. I mean, obviously, you do 30 days, I mean, earlier than that, but as far as the state exam is concerned, 30 days. And then basically, I would be acting like the broker so that the brokerage company can stay open and people can do business. And how long is this temporary broker's license good for?
A year?
1 year. Good. Ding, 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 ding. So during that year, do I have to go take the course, pass the state exam, et cetera, et cetera?
Yes.
Yes, absolutely. If I didn't do that within that year, can I extend the temporary license?
No.
No.
Does that mean I am now a broker?
No.
No.
Nope.
All right, exactly. Okay, so we got that all good. All right, so the broker of record again is the client for us because we signed an agreement. If the broker decides to open up another brokerage, another office, a branch office, does that branch office have to have its own license?
No, it can be under the main.
It has to have a branch office license.
It does.
Yes. And the branch office license is $150. So if the broker opens up another branch, they have a branch license. Can the broker manage 2 offices?
Yes.
No. They have
Under-
to hire. They have to hire a broker salesperson to manage the branch office.
If it's under the same broker though, you could manage 2 different offices. Like
No,
for
you cannot.
oh,
They own it, but they cannot manage it. Key word, 2 different words. Owning and managing are 2 different words. So the answer is, the question is, can a broker of record or a broker manage 2 offices? The answer is no. Do they own both offices? Yes. So if they have a second office or a third office or a fourth office, they will have a branch license for each additional office, and they will have to hire broker salespeople to manage the office. The broker salespeople and the broker, do they physically have to be in the office?
yes.
For how long?
5 days.
Okay. And for how many hours?
I believe it would be a 32 to 40-hour work week.
Ding, ding, ding. Good job. Good job. So yes, they have to physically be there. Can they have another job if they're managing the offices?
I don't believe so.
Correct. Ding, 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 ding. Good job. All right. So they physically have to be there. They cannot have another job. They have to be there between 32 and 40 hours. And it could be basically, they could set it up that they do 1 weekend include a weekend or not a weekend day, doesn't matter, but they have to be open for 40, during public hours. All right. You guys did good on the types of agency. All right. We talked about buyer's agency, disclosed dual agency. So forgetting, and again, let me just tell you this. Don't worry about the buyer representation right now when you're taking the state exam, because those questions are not in there. So don't cloud your head with the discussion that we had earlier. Okay. Please, please, please don't crowd your head with that. Just go by what we've been talking about. So buyer's agency, there can be a buyer's agency agreement. Then it could be that they pay us a commission or a combination. That's basically what it says in the book. That's all you need to worry about. All right. Now let's talk about disclosed dual agency. All right. Can a broker who is, no, wait, let me rephrase that. Can a salesperson be paid by the seller and the buyer?
Yes.
Yes. All right. The answer is yes, because they have a buyer's agency agreement for whatever the dollar amount is, and the seller agreed to pay whatever the dollar amount is, and therefore the salesperson who's representing the buyer can be paid by the seller and the buyer. But they can never be paid if the brokerage company is representing both parties, meaning you, the buyer's agent, and the seller's agent are working for the same brokerage company. All right, everybody good with that?
Can you just explain that one more time, please?
Sure. Under dual disclosed agency, all right, the salesperson representing the buyer can be paid by the seller and can be paid by the buyer because they have a buyer agency agreement. So for example, I told the buyer, I only work for 3%. So if the seller is only going to offer 2%, then I expect you, the buyer, to pay the difference of 1%. All right. And they agreed to that. So in this case, I can get paid by the seller and the buyer. But if I have a buyer that is interested in a property that is being represented by my brokerage company, okay, meaning the listing agent is representing the seller and they work in my brokerage company and I work in the same brokerage company, then I can only get paid by the seller. All right. Just use that right now for what the state exam is asking. Don't add anything to that from real life. Everybody good with that?
Yes.
Okay.
Very important. Okay. Now, the next question that I have, if I am disclosed dual agent, all right, and I do a CMA for my buyer, do I have to share that with the seller?
Only if the buyer gives you permission.
Oh no, I have to share it with them because whatever I do, the other side has to know because we're disclosed dual agent.
Okay.
The same thing if the seller asked for a new CMA because they didn't like our offer, all right, and the seller's asking for a CMA, then that seller's agent has to give me their CMA as well. All right. And we're only talking about the real estate transaction. All right. That's all we're talking about. We're not talking about personal items, personal information. No confidential information can be talked about when we are in disclosed dual agent. Everybody good?
Yes.
Yes.
Okay. All right. Those are all the main things that, Okay, so here's regarding contracts. Remember, we talked about it. We said that 18 years of essentials, right? 18 years or older. All right, we have an offer and acceptance. So an offer and acceptance would be considered a meeting of the minds, meaning that all parties agreed to what's on paper, right? And then after that, we have the consideration, which is the value. The next one I forgot to mention, it's legality of object. That's the other part of a valid contract. All right. And then after that, then we have the signature, right? So legality of object is the main thing that I forgot to mention. All right. And then that's regarding that. All right. So let's just go over that again for a moment. A valid contract, we already stated, has a beginning date, has an end date, has to be 18 years or older. There has to be an offer and acceptance, okay, where we have the meeting of the minds. All right. There's got to be a consideration. We're promising what the value is. And then it's got to be for a legal purpose. All right. If therefore this and signatures, therefore this contract is a valid enforceable contract. Okay. Now, could we have potentially started with our buyer in a verbal form? The answer is yes, but the parole evidence rule, that's the key right here, states that a written contract takes precedence over oral agreements. So no matter what, for us licensees, even if we start with an oral contract, a verbal contract, we still have to put it in writing because the statute of frauds states that anything to be enforceable must be in writing. Everybody good with that?
Yes.
All right. All right. We talked about void and voidable. Okay, so we said voidable is when it seems valid, but there's something missing. All right, or it could be rescinded. Okay, so that's voidable. Void means that it never was legal to begin with.
Got it.
All right, that's the difference there. All right, we have bilateral means two-sided, two or more people. Unilateral means one person. Okay. The difference between a bilateral contract and a unilateral contract is, let me see if I can remember it. It's so an option or unilateral contract. I will do this if, keyword, if you will do that. That's a one-sided unilateral contract. A bilateral contract is I will do this and you will do that. All right. So that's a bilateral. Is a lease a conveyance?
No.
Yes. Is it transferring the right to occupy and possess a property?
Yes.
Yes.
So it's a transfer, therefore it's a conveyance, but it is only conveying the right to use and possess the property. So a lease is also known as a demise. So the demise is the word transfer, right? And that is the conveyance. Okay. There is conveyance that grants the leasehold estate. All right. So a lease is demised. A person is demised the property through a lease, meaning we were transferred the right to occupy and use the property through a lease for a specific period of time at a specific rate, blah, 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 blah. Okay. All right. Okay. Unenforceable contract, again, means that we can't force one person or the other person to do something. So that would be an unenforceable contract because there's a defect in it. Now, we don't talk about specific performance, but we need to know what that means. It's basically a lawyer item that they do, and basically they're saying that if you don't transfer that property, if you don't give me the deed to the property, I'm going to sue you for specific performance. So in this example, specific performance means that I am going to force you to give me the deed because I paid you. All right, does that make sense?
Yes.
Okay. Or we could have a specific performance where the seller stayed on beyond the closing date. Okay, and they're not moving out. So again, here we can have a specific performance saying, listen, if you don't clear out, we're going to sue you and force you to get out so that we could get our house. All right, that's basically what we're talking about. All right, discharge of contract. Okay, so if a contract is executed, all right, what does that mean? There's two meanings to it. I want the more important meaning.
Signed?
That's the least important. Well, it's important, but not the main important one. What's the other version?
It's been
It's completed, right?
Yes.
If that contract is completed, it's terminated, it's a positive thing, and yay, we're getting our commission. Woohoo! All right. So that's executed. All right.
Oh, it's executed after everyone gets paid, even. Like
It's executed before everybody. It was executed when it closed, when the property transferred. So when does the property transfer? What is considered the property has transferred?
During closing?
10 days
Okay, but
after.
no.
When it's noted in public records?
Nope.
Recorded.
Nope.
When it's delivered to the
Ding,
buyer.
ding, 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 ding. Bravo. Delivery. All right. And when is the delivery? At the closing. All right. So delivery at the closing, it's implied. Again, that's another word. It's implied that it was delivered at the closing and therefore they've taken possession or they own the property. Yes, it's going to be recorded eventually, but when did they get it? When did they take ownership? When the deed was delivered. All right. And that's a question that they would be asking. All right, let's see what else. Okay. Oh, we already said that. We did that one. Okay, but if a broker takes personal money and puts it into a trust account, what is that called? What was that, Luz?
Yes.
What was it called?
Commingling?
Commingling, yes. Ding, 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 ding. Good job. Okay. But are they allowed to use personal money to pay the bank fee on the escrow account?
Yes.
Okay, good. Ding, ding, ding. Can the escrow account be interest bearing?
No.
No. All right, good. We already talked about, okay. Let's just say we have a deposit of $50,000 in the escrow account. And through legal blah, blah, blahs, we get a legal letter. The broker gets a legal letter that says, okay, of the 50,000, you're going to be using 30,000 for your commission. What must the broker do?
Put it in writing.
No.
Have
The
to
money
send
has,
us.
the money has to go back and then be paid to the broker for the broker to pay you. You can't take the money directly from the escrow.
Who can't take money directly from the escrow?
The agent.
Well, I didn't say that. I said in the letter, in the legal lawyer letter, it stated of the $50,000, 30,000 will be used for commission. What must the broker do?
Has to give the client a list of how the money is going to be used.
This is a legal letter from the lawyer.
Do we have to give it back? Give it back?
No. We're getting a commission out of that $50,000. Is commission personal money?
No.
No.
Why not?
No.
Doesn't the broker get a commission?
Yes.
And isn't that personal money to the broker?
Yes.
Okay, so what happens if the broker leaves personal money in the escrow account?
They could get in trouble.
Right, what's it called?
Commingling.
Thank you. So, if the letter states that the broker has $50,000 in the escrow account and 30,000 of that is commission, what must the broker do?
They have to take the 30,000 out and put it in their personal account.
Ding, 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 ding. Thank you very much, Lavada. Good job. All right, because
Took a while.
commission is personal money. And if we leave personal money in the escrow account, that is commingling. Now, within how many days must that broker take out the commission?
Five.
That's what I was going to say.
5 what?
5 business days.
5 business days. Ding, 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 ding. Good job. Good job. Because we have to deposit monies into the escrow account within how many?
5 business days.
Ding, 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 ding. Good job. All right. Okay. All right. Well, I think we've covered everything in all different ways. All right. Does anybody look at that? We're 3 minutes ahead. Wasn't planning that, but it worked out that way. Any questions? How do you feel about this?
It's a lot.
Okay.
It's a lot of information.
Okay. Do you feel?
I'm sorry to ask, but is there any chance